Yes. Of which group? Have you served notice upon other side? Without notice, no, sorry. The hearing stage. Monthly list of June. Under the heading old hearing or contested contempt.
The contempt application of just the order is of Justice BHATTACHARYYA will not only is going to move for the first time.
New contempt, monthly list of May.
The contempt application arising out of the order passed by Justice Chatterjee.
What is the stage of contempt?
The first stage.
First time. It has never been heard.
It was heard once.
Old contempt, monthly list of June.
My Lord, may I permit one contempt application by order passed by the Honorable Justice Punab Kumar Chattopadhyay.
What is the stage of contempt?
First time, my Lord. Never been heard.
Old contempt, monthly list of June.
May I be permitted to mention, subject to losses kindly, may I be permitted to mention, my Lord, hearing group 5, my Lord.
Of which year?
2015.
Which group?
Group 5, Panchayat.
Have you served notice of?
Yes. In fact, I had to serve the writ petition once again because there's a change in the advocate. So.
Monthly list of May.
Grateful.
Heading Panchayat hearing.
There too. Same matter. Yeah.
May I kindly mention, my Lord, for inclusion in the list, a very old matter of 2008, my Lord. We have served the other side, my Lord.
Which group?
Group 9, my Lord. Residual. If my Lords kindly permit for hearing, it is a 2008 matter, my Lord.
Monthly list of June.
With reply.
Have you served notice upon other side?
Contempt. If the order passed by Honorable Justice
Contempt. What is the stage of contempt? New contempt. Never been heard. Monthly list of May. New contempt.
New contempt application arising out of an order passed by Justice BHATTACHARYYA.
Writ petition. New contempt, monthly list of May.
For correction. For correction.
Yes, show me the order.
Actually, my Lord, taking the my Lord was passed an order for correction. My Lord, my Lord have passed the order on the next step. It will be the second line in case of first line. Petitioner
Check it from the order. It may not tally with the
order,
from the order sheet of the file.
Actually, my Lord, I have a backside. I have also
That is the server copy. Server copy may not tally with the sheet of the order.
Yes, sir. Then my Lord have passed the order in the second page. It will be the second line. My Lord, kindly go through the order, my Lord. Second order, my Lord. Correction order.
It may not tally with the order of the order sheet of the এটা ফাইলটা বার করে একটু দেখাবে তো Yes.
Lord, may I have your lordship's kind leave to mention a matter for upgradation. Lord, for upgradation, the matter is running as item number 216 in the monthly combined list of your lordship's list. Lord, the matter is running since 2021.
What is the urgency?
Lord, in a nutshell, the fact is the petitioner is the owner of a land which was classified as Bastu. Now, in the assessment roll of the municipality, in the record of right, everywhere the property was classified as Bastu. Now, the petitioner picked up a quarrel with the private respondents what the land grab was. Now, what happened? Ultimately,
what is the urgency?
My Lord, what happened? The municipality, at the behest of this private respondent, issued a notice to the petitioner saying that this is a water body. The petitioner is illegally filling up the water body. So, the petitioner has been deprived of enjoying his own property, and this matter is pending since 2021. I haven't
wait for some time. I don't. It's not an so urgent matter. Sorry. Yes.
This is a contempt application, Lordship, arising by Her Ladyship Honorable Justice Lapita Banerjee, Lordship. This is a contempt application.
What is the stage of contempt?
It's the first time, Lordship.
New contempt, monthly list of May.
Well, inclusion of hearing matter, my Lord. Inclusion of hearing matter, Group 9, 2017.
Group 9 hearing matter?
Yes, ma'am. With notice to the other side.
Have you served notice of
yes,
the other side?
Yes,
Monthly list of June.
Lordship, may I permit to mention a matter? This is a contempt application, Lordship.
Arising out of the order passed by which court?
Lordship, Honorable Justice Devi Prasad De.
What is the stage of contempt?
Lordship, old contempt. Lordship, old contempt.
Old contempt, monthly list of June.
Prescription of application.
When dismissed for default?
30th November 2023.
38 November,
30th November.
30th November 2023. Within time file.
Yes.
Application, monthly list of May. Have you served notice upon other side?
Lordship, throughout the day I can serve, Lordship. I'm serving.
Have you served a copy of the restoration application upon other side?
That
But is the
application for restoration, my lord.
when dismissed for default?
This is my lord, the 2019, my lord, I have filed within time, my lord, restoration application. 2016 matter, my lord, group 9.
Monthly list of June
What is the contempt application in
under the heading application? Yes.
in pursuance of the order dated passed by His Lordship Ashok Das Adhikari.
What is the stage of contempt?
My lord, and the last time the new order has been passed, so
Old contempt, monthly list of June.
saying for
Yes.
contempt application.
Arising out of
Honor-
the order passed by which court?
Honorable Justice Mousumi Bhattacharya Court.
What is the stage of contempt?
Earlier occasion passed the order, other side copy service.
New contempt, monthly list of May.
Grateful Lord.
item number 1.
My lord, I'm for the petitioner, Lordship. Lordship, on last occasion, Lordship was pleased
We
to
filed a
আসুন
দেখো তো আমার অর্ডারটা দেখি ফাইলটা ফাইলটা বার করে ফার্স্ট লাইন কারেকশনটা না সেকেন্ড লাইন দেখে নিই। অনেক সময় না সার্ভার কপির সঙ্গে অর্ডার শিফট
Lordship, on last occasion, my lord was pleased to direct me to serve again to the private respondent, Lordship, if possible to the WhatsApp number or to the email ID of that person. However, could not trace out, Lordship, his WhatsApp number or email ID.
Yes, what about the service upon respondent number 8?
Lordship, on last occasion, my lord had directed me to serve him upon either by WhatsApp or email ID because it was showing address is not found in the track consignment. But Lordship, we could not track out the WhatsApp number or the email ID of that private respondent, Lordship. Lordship, my humble submission before my lord is that whether or not there is a whether or not there is an illegal construction in the area, that is a report to be submitted by the KMC, Lordship. Lordship, kindly, if my lord peruses, Lordship, seek for a report from the KMC whether there is an illegal construction or not. My lord, I have the
It is
photograph.
an illegal construction. Without hearing respondent number 8, how an order can be passed?
Lordship, I bow down before your Lordship. Then a hearing may be conducted before the KMC, Lordship, because I have the
No, you have
photograph
to
also.
ensure that a service upon the respondent number 8 has to be ensured, not in this fashion. No, sorry. Sir,
Lordship, then-
respondent who needs to be heard.
Lordship, then grants me 1 week time. I shall give my last chance if possible, Lordship.
Have you served notice by post?
Yes, Lordship. I
What was the report? came?
address is not found.
Show me the envelope.
Lordship, I apologize. It's not affirmed, Lordship, but
Show me the envelope.
Lordship, this is the track report, Lordship. It's not affirmed, Lordship. Item on hold, address is not found.
What is the address you have written in the cost title?
Lordship, this is a
Come to internal page 2 of the writ petition. Respondent number 8.
Noresh Mitra Soroni, Belsta Road. Police
What is
station.
that? This road is unknown. It is at Baliganj.
Lordship,
Belsla Road. Is there any road?
Lordship, then I need to take instruction because this is a change brief. Lordship, the advocate on record is
What
also
sort
not
of
here.
address is this?
Lordship, then I need to take instruction because
Show me the
বেলতলা রোড আর কি হলে তো ঠিক আছে।
What sort of postal slip is there?
Lordship,
Read your postal slip. I will impose heavy cost upon the petitioner. Read the postal slip. Bali. Beltola Road, Bali.
my lord, the pin code,
How much cost is to be imposed
Lordship,
for wasting judicial time?
Lordship,
This matter was heard on last occasion, 15th April 2024. I had to adjourn the matter due to want of service, and
Lordship,
today
this
matter
is-
has been
this is
posted at the top of the
Baliganj.
list.
This is Baliganj. I think it has come from the computerized slip because the pin code is matching, Lordship. The road is matching. It's Baliganj and it's Bali over here.
Send directly by hand to the respondent number 8 by
Lordship,
tomorrow.
Lordship, I shall inform the advocate on record because Lordship, it is showing Bali and it is Baliganj. The pin code and the road's name is same. I think since Baliganj is a bigger name,
That
Lordship,
may
I
be
think they've
possible.
not come,
That
Lordship.
may be possible. But you have given a wrong road name in the cost title too.
Lordship, then that I need to take instruction, Lordship, because this is a change brief and the advocate on record is also.
That
Lordship,
is
I
not
bow
the
down,
explanation.
I bow down, Lordship.
বেলতলা রোড
So, but in the postal slip, Lordship, it's Beltola Road only. Maybe there is some typographical mistake over here in the cost title, Lordship. And the Baliganj is Bali, Lordship, and the pin code is also matching, Lordship.
Correct the cost title. Correct the cost title address of the respondent number 8 in the cost title. I'm here and now.
Lordship, the advocate on record is not here, Lordship. That's what.
You do this. You do this.
Lordship, Lordship.
Yes.
My lord directs me, I'll cut the cost title, Lordship.
Matter is taken up for consideration pursuant to the order dated 15th April 2024. When the learned advocate representing the petitioner has prayed further accommodation to effect service of notice upon the respondent number 8, it has been submitted by the learned advocate representing the petitioner that leave needs to be granted to him to amend the cost title of the writ petition in order to insert correct address of the respondent number 8. Next paragraph, let cost title of the writ petition be corrected in course of this day by inserting correct address of respondent number 8. Stop. Next paragraph, petitioner is directed to serve notice upon the respondent number 8 within by 26th April 2024 and file affidavit of service. List the matter under the same heading for further consideration on Monday next.
Lordship, great.
Item number 2.
Time for the petitioner.
Who is representing 9-1 and 9-2? Respondent
My
number.
lord, service, my lord, we have filed the affidavit of service. My lord, despite service, my lord, none appeared. But my lord, for 9 and 10, my lord, who are my lord the deceased respondents originally, the respective fathers of my lord 9-1 and 9-2. My lord, there, my lord, your lordship had directed us to, my lord, serve upon the concerned advocate.
9-1 and 10-2.
9-1 and 10-2, and their respective fathers, my lord. So, my lord, the advocate had appeared on the last occasion, if your lordship recalls, and he, my lord, made a statement that 9 and 10 have alienated their interest in the suit property, and there's no question of them contesting this any further. We'd serve the advocate, my lord, he'd come and he'd, my lord, appeared on the last occasion. And your lordship, my lord, perhaps heard us at reasonable length. My lord, if your lordship recalls, my lord, I was, my lord, appearing virtually on that occasion.
But it has been recorded in the last order that no one appears on behalf of 9-1 and 10-2.
Yes, my lord, they have not been appearing. But the advocate, my lord, came and he said that 9 and 10 have alienated in their lifetime, alienated, my lord, the
What about 9-1?
my lord, service is complete upon both 9-1 and we filed our affidavit of service file. Affidavit of service file করেছিলে তো? My lord, service is complete upon them, my lord.
And 10-1?
I'm sorry.
10-1, nobody is
Passed away, my lord. She's a widow, she's passed away. And accordingly, my lord, corrections were made in the records also. Further amendment was directed to be carried out, it was carried out.
Yes, what is the matter?
There is, my lord, a really short point, if I may, my lord, please, your lordship. My lord, there is a building, it's a ground plus 4-storied building. My lord, I had purchased a flat from 9 and 10 over the developers and the landowners. They were, my lord, on the plot of land constructing the building. I was sold, my lord, a flat, namely flat 4B of 484 square feet, along with, my lord, a roof of 621 square feet, with further right, my lord, to construct on the roof. And in addition to this, I also was, my lord, sold a proportionate share in the common areas of the building. This sale, my lord, happened on 4th November 2009.
Where is the order dated 29 June 2012?
At page 170, my lord. I'm gonna come to that, my lord. Before I, my lord, place that order.
Yes.
Yes. So, my lord, I had purchased a flat on the 4th floor, along with the roof, 621 square feet, along with proportionate share, my lord, in the common areas, with a further right to construct on the roof. This is what was sold to me on 4th November 2009. The sanction plan, my lord, was of the year 2006. And that was the plan which was shown to me, pursuant to which, my lord, I purchased this property. Now, my lord, while the construction was ongoing, I came to realize that the construction was not happening as per the plan of 2006, but instead there were deviations. So I made certain complaints saying that there is illegal construction ongoing. The construction is not as per the plan. The corporation did not act. So I filed a writ alleging inaction on part of the corporation. In that writ petition, the regular order was passed directing the corporation to address my grievances within a fixed time frame, 8 weeks, I suppose. It is in compliance of that order, that some hearing happened, and this order at page 170 was passed. This order is impugned before your lordship.
Hey, building rules turn out.
This order, is impugned before your lordship.
But they have followed the building rules of rules 25. There was a changes brought in.
I'm coming to
You
that.
have to change the. You have to challenge this order which has been passed under section under rule 25.
This has been challenged, my lord.
Come to building rule 25.
My lord, I am not disputing the fact, my lord, that my lord,
26, rule 26.
my lord, I am not disputing the fact that a plan cannot be amended. It certainly can be amended. My lord, in this order at page 70, it has, my lord, been written that there was an amendment of the plan. The amendment of the plan was allowed, and the new construction which is happening, which I allege was deviation, is as per the new plan.
Yes.
In view of that, my lord, I have, my lord, in my writ petition, not only challenged, my lord, this order, but I have also, my lord, challenged the decision to amend the plan. And on
How that is possible at that point of time? Because this building rule was sanctioned on along with
on 29th June
29
2012.
June 2012.
Yes, my lord.
29 June 2012, when construction has been made in terms of the building rules, what you are doing at that point of time?
My lord, I had made a complaint.
You purchased the property in 2009.
Yes.
Now in 2009, when you purchased the property, there, according to you, that the roof right, a portion of the roof right was given to you.
Yes, my lord.
Now for making construction.
Yes, my lord.
Now that roof right diminished in view of the building rules, in view of the amended plan.
Yes, my lord.
Which has been issued in terms of rule 25 of the building rules.
That
Now,
apart,
this
my lord.
was done on 29th June 2012.
Yes.
Now for 3 years, what you were doing when this construction was going on?
My lord, I filed a writ petition. My lord,
Today, think about the position in terms of the deviations made in terms of the building rules, approved rules. This construction has been made, and this construction was probably concluded in 2012 or 2013. Now, today we are in 2024. 2024. Can that be done? And that too, prejudicing the other occupiers of the building.
My lord,
You're not a party. Absurd prayer today.
No, my lord. May I, my lord, try and satisfy my lord? My lord, kindly, my lord. Nobody will be prejudiced at all.
I will grant you leave to approach the civil court for getting appropriate relief. If your right, which accrues in terms of the conveyance deed, is denied.
But my lord, the civil court will not, my lord, interfere, because they'll say that the High Court never interfered with the plan.
May I pray for appropriate compensation?
That will never see the light of. Yes. My lord, may I kindly allow me, my lord, kindly, my lord, just, my lord, for few minutes, my lord, kindly, my lord, let me put my point across.
It is impossible.
My lord, I have, my lord, never.
Today, if I accept your contention, then the developer has to follow its original building rule.
No, that
original sanction plan,
may
not the amended sanction plan. If original sanction plan is to be effected, in that event, the entire construction or the part of the construction which has been made in 2012, 2013 has to be demolished, affecting rights of other purchasers of flat.
That is perhaps not so. May I satisfy my lord on that? Malad, today in the ground plus 4-storied building, Malad, the ground floor is common. The first floor is still owned by respondents numbers 9 and 10 and their heirs, which they, Malad, came and said that they've alienated. Malad, I have instructions. The first floor is, Malad, owned by them. It is rented out. Malad, to a commercial user. Now, Malad, the second and third floor has been alienated. The alienation of the second and third floor in the deeds, it has been specifically stated that this sale is subject to the decision of the outcome.
Answer the query of the court from 2009 to 12, what you were doing.
Malad, I purchased in 2009. As soon as I saw, Malad, constructions being made, I started writing to the KMC. The KMC, Malad, did not act.
The right of the other purchasers have been fortified.
Malad,
It's a flat, it's a building having different flats.
Yes. And different occupants are there, all are not before
How
lordship.
many occupants are there?
Exactly, I don't have.
Malad, I have the exact details. Malad, kindly,
How many
Malad,
occupants are there?
Malad, second floor has been alienated fully to one person, and third floor has been alienated to another person. Now, Malad, in a 4-storied building, I am on the 4th floor. I have roof rights. On the 3rd floor, there is, Malad,
See the position. What is the wrong of the developer? They have followed Rule 26, made an application. Procedure was followed.
we have suppressed the fact, Malad.
Procedure was followed.
No, that
And then-
procedure was
then-
not followed, Malad.
Then after following the procedure, this was granted. Now deviation was permitted. Internal deviations were made. Now after the internal deviations were made, court did not pass any order in the first writ petition directing the authority to take decision. Decision was taken ultimately in 2012, and today we are in 2024. So therefore, if today, if this court directs the developer, now developer has might have alienated all the flats. What interest that this developer has got today?
Malad,
Tell me.
I will tell you, Lordship.
Tell me if today developer has no interest, he has purchased he has sold out all the flats.
Malad, I'm only going to.
Who will undo the things which has been done in terms of the deviated sanction plan?
Malad, I'll try and resolve. Malad, I'll try and resolve this. Malad, kindly, Malad, let me try and work a way out. Malad, the building as of today.
Mr.
Kindly
Naik,
appreciate the building.
Carry out an inspection and indicate how many occupants are there in the building, and whether they are the flat owners or occupiers, and whether developer has got any connection so far the building is concerned, since completion certificate has already been and submit a report.
I will bow down, lordship, but only one point I say, my lord. Petitioner's prayer, if my lord consider, if he says that there is deviation, now, my lord, and he is having, my lord, proportionate right over the, my lord, common areas and all that. Not only he, others are also having. And my lord, he passes any order in his favor, very well, let it be demolished, or you get your shared portion. Others, what about others who are not before lordship?
That is what court is saying.
My lord, may I?
How their purpose will be
So
served?
therefore, that's why in order to assess the appropriate situation which is there in the building in question, you carry out an inspection and submit a report indicating how many flat owners and are there in the building, and whether still developer is connected to this building in question or not.
I will.
My lord, may I, my lord, say one thing?
I will.
My lord, I have obtained the deed. My lord, the deed, my lord.
The writ petition is heard.
My lord, my senior Mr. Banerjee,
Of the
dear
learned advocate,
lordship, may I take short leave, my lord?
learned advocates representing the petitioner and Kolkata Municipal Corporation. Stop. Next paragraph. In the writ petition, the order passed by the executive engineer within bracket C, close bracket building department, comma, Borough 9, dated 26 September 2012, is under challenge. Stop. Petitioner is aggrieved by the deviation of plan which has been made by the concerned authority of Kolkata Municipal Corporation based on the application made by the developer in terms of the relevant provisions of the Kolkata Municipal Corporation Building Rules, 2009. Next paragraph. Stop. It is also submitted on behalf of the petitioner that the person who constructed the building needs to undo the steps taken pursuant to the deviated sanction plan, and Now, the construction of the building should be in compliance with the original sanction plan date of 2006. Next paragraph, having considered the submission made on behalf of the petitioner, it appears that present position of the building needs to be ascertained. Stop. The concerned authority, the concerned official of KMC is directed to inspect the building by fortnight from date and prepare a report disclosing how many flat owners / occupants are residing at the premises in question and whether still the developer is connected in any way to the premises in question, to the said premises. Stop. Next paragraph, let such report be filed, let such report be placed before this court after 3 weeks. Next paragraph, list the matter under the same heading for further consideration on 13th May 2024.
There are essentially, my lord, if I may point out,
Next matter.
grateful, my lord. Item number 3.
Pursuant to the direction of your lordship, my lord, the notice has been served upon by the private. But from the
Just a minute.
আর সবই তোমার
Who is representing respondent number 5?
Although from the affidavit of service, it appears that it has been dispatched but not service completed, my lord. Kindly.
Service is not complete.
Yes, my lord. I've seen that. কবে ছেড়েছিলেন? কবে ছেড়েছিলেন? It was sent on 19th, my lord.
And 5 on 19.
সেই জন্যই।
What about the corporation, whether the
my lord,
pension has been settled?
No, pension has not been settled and we have not released the pension. Family pension is
Provident fund and group insurance benefit has been given.
yes, we have disbursed. Only when at present, my lord, the
For the
family
nominee-
pension
Yes, as
and graduate.
he has been shown as the nominee, but so for the nominee
nominee.
function of the nominee is concerned.
Real complete service and come back. Issue. Simply not today. Next Monday.
Malad, instead of next Monday, second, Malad, is it possible?
No, second.
These matters are taken up on Monday.
Second is hard.
Item number 4.
Malad,
You have difficulty on Monday?
Yes, sir. Monday. Any other day? Second, Malad.
Well, adjourn till 2nd May.
Great.
Second May.
Second. Affidavit completed, the case service completed.
Yes, who is for the petitioner?
Well, I'm for the petitioner.
Where is the decision?
I appear for the interest. Coca-Cola Corporation has taken the property as a KMC market. That has resolution been taken on 9th March 2024. Therefore, further we shall proceed with for granting them.
No, there is an order. It was recorded in the. Do you have the copy of the last order?
My lord, I have last occasion a report was filed before your lordship. That has been accepted by the mayor and council in the in their meeting dated 9th. The proposal has been accepted, man.
No, you have to take final decision for
The final decision decision has been taken, my lord, on 9th March.
Show me the order, report.
That decision in the MIC decision, my lord. It is at a copy.
রিসর্ট করা গেছে যে কি শর্তে দিয়েছে
কি আছে ইন্টারপ্রিটার এনজিএম কেএমসি ওটা তো কেএমসি আমি এখন
Is this authority that V&S?
VNS yes
valuer and surveyor department. Chief valuer and surveyor department.
What is the original report?
But original that is the minute of the line there. But original report I have filed it, but earlier occasion I have filed it this.
Then everything is approved.
Approved. Now we have to grant them the license on payment, on their payment. The terms and condition which will, as far as the terms and condition will be laid down by the market department. One inspection is to be taken who are in possession actually, then my lord, we grant them.
Have you given a copy to the
my
lawyer?
lord,
Well, so far as the so
Give
far
a
as
copy. Give a copy.
I have one.
See the decision of the mayor. Mayor in council.
আগের রিপোর্টটা তো আমাদের ইন্টারনাল ওইটা যাবে না
আগে যেটা কোর্টে ফাইল হয়েছে
কিছু নেই এটার পরে এইটাই হচ্ছে আমাদের
না আগেরটা নেই আমার
ওটা
আগে যেটা ফাইল করেছিলাম কি
well, if that be so, my lord, that was my only prayer. My only prayer was, my lord, that the respondent authorities be allowed to the petitioners to deposit the balance amount, and my lord, allotment letters be issued.
How much time will be required for issuing allotment letters?
My lord, 6 weeks at least, my lord.
6 weeks.
My lord, the inspection
God, you have not
madam,
said 6
inspection
years.
to be taken. Therefore, in the meantime,
Already everything is
please, I mean,
approved.
everything. Madam, we are not
Everything is
charging anything
approved.
more. Yes,
Wait by 2 weeks.
and my lord,
Enough time has been given for taking
that's right.
decision.
Then
So therefore, don't bargain with the court. Do it by 2 weeks. And
ultimately,
issue-
as per my lord's decision order, my lord, we have taken this decision that we shall take the property from the KMD, and we approached before the KMD. KMD has said that you take the property. Therefore, we take
My lord,
further
to
decision.
to
Just-
that extent, my lord, in view of this submission, we were added. My lord, the difficulty is, my lord, that after merger, the office was shifted. Some
Now
files
you
were
have no role to
misplaced.
play.
My lord,
Already it has been handed over to KMC. KMC has taken a decision.
on what terms and condition came the Astral? It was the property
How
of
the
Astral.
interested? It is already stated that the proposal of so and so occurs.
Yes,
Hawkers.
it is absolutely up to the KMC because
Now, in the previous order, you were not there. There was a submission. Therefore, it has been presumed by the KMC that the ground floor and the entire first floor of the building in question was handed over to KMC by NKDA at the material point of time.
yes, that to ascertain, we could trace out the file last Friday.
Not required.
I-
Mayor has
I-
already taken decision.
I have been informed
Please
that
enter into the issue and don't spoil the entire event. Yes. Since the KMDA may be in charge, that's why court directed you to appear before this court. But now you have nothing to do in this matter since Mayor has taken a decision.
as it.
So let me dispose of the report.
My lord. So far as this report is concerned, my lord, that was my
Directing the KMC to issue allotment letters in favor of the
Grateful.
petitioners on making necessary payment.
after my lord receiving the payment.
Matter is heard in presence of the learned advocates representing the petitioners from Kolkata Municipal Corporation and Kolkata Metropolitan Development Authority. Stop. Next, during course of hearing, the learned advocate representing KMC has placed before this court. It's a decision of the mayor in council. Decision of the mayor in council, which has been signed by the mayor. And the document is dated 9th March 2024. Stop. A copy of the said document dated 9 March 2024 is placed before this court, and a copy of the said document dated 9th March 2024 is taken on record. Next paragraph. On perusal of the decision of the mayor in council as taken টা কেটে দাও. Mayor in council, it appears that allotment of permanent stalls to the bona fide evicted hawkers from CIT building, comma, plot number 9B, comma, CIT scheme, hyphen, capital Roman 6, capital H within bracket, Roman, capital M, close bracket, on Ultodanga main road was approved. The concerned authority of KMC also took note of the fact that the amount, some amount was received from the hawkers previously. Stop. It was also decided in the meeting of the mayor and council the name of the hawkers according to their physical possession of stalls in the market as per usual terms and conditions of KMC. Was approved and chief valuer and surveyor, V&A,
Yes.
chief valuer
and surveyor.
As well as chief manager within bracket market,
Market.
close bracket, were directed to take necessary action for recording names of the hawkers. Stop. Next paragraph, copy of the said decision of the mayor in council as it appears from the document dated 9th March 2024 is made over to the learned advocate representing the petitioners. Stop. Next paragraph, in view of such decision taken by the mayor in council, only exercise which is required to be done by the chief valuer and surveyor and chief manager within bracket market to allot of to finally allot the stalls in favor of the hawkers, including the petitioners, and record their names on consideration of physical possession of the hawkers / petitioners of the stalls at the market in question in terms on the basis of usual terms and conditions and on payment of requisite charges. Stop. Let this exercise be carried out within a period of 10 weeks from the date of communication of this order. Upon making necessary, upon identifying whether the petitioners are possessing the stalls in the market in question. Stop. With the aforesaid directions, the writ petition stands disposed of. there shall be no orders to cost urgent xerox certificate. Do it by 10 weeks.
Wait, 2 minutes.
Item number 5. Appear for the petitioners. Pursuant to the last direction of your lordship, I have served notice on the learned special officers of this court.
What about the report of the corporation? Where is Mr. Ghosh? Where is the affidavit? In the form of affidavit. This order was passed on 4th March 2024.
Yes, it is by our mistake.
Last occasion also time was prayed for on 1st of April 2024. This court adjourned the matter on your prayer.
Yes, I that date, but I was not aware of all the acts.
Not a pass.
Not a copy. नहीं copy. But it has been stated that there is a water body which has been filled up partially.
It has been stated
in the report.
And that the corporation may say not whatever it, but
you last occasion you submitted previously that it's a park.
Please see not they wanted to put it up as a park. I'm not before
now the issue has been resolved. Now there is no
now I'm not
the land in question is under your possession. You want to
construct a boundary wall.
A boundary wall. But it has been to that extent nothing has been stated.
Correct.
But only thing that has been stated that see the report.
Not sir.
Give a copy to him.
Not the special officers were manhandled. So was my daughter. Now I'm not the
special officers were
manhandled. So they had to file an FIR.
with the local police station. Now, not so was my daughter manhandled. Not so I had to
See the report. Do you have a copy?
I have only one copy now.
See the allow him to read the report.
Twenty 16, not this is all not by way of aftermath of not initially not this everybody not understands why these hoardings are set up in front of the private properties. The 2016 notice is being sought to be not projected before this honorable court. Section 53 of the Town and Country Planning Act cannot have any manner of application. But I can show to your lordship, not immediately satisfied.
That is not the issue in this.
But the issue is on this reputation. It's my property. I wanted to protect it. But there was a hoarding put up that it is a KMC park. Sought to be
But with regard to this last paragraph of the report, court cannot make any observation.
Environment and Heritage Department previously
Dispose of the
issued
reputation.
notice against illegal filling of water body
Since
undertaking.
your apprehension regarding converting your land into a park has already been redressed, and let the writ petition be disposed of. With regard to the report indicating that there is a water body and filling up, and there is a complaint regarding filling up of these water bodies. Court will not express.
No, that is a different cause of action, right? Not I had twofold prayers. Not one is for removal of that hoarding of KMC, which the KMC's Learned Council on 17th February 2016 candidly submitted in court that we don't want to set up a KMC park there. It's a land. Remember, the special officer was the joint special officers were appointed. When they wanted to take symbolic position, they were manhandled. So was my daughter. So they had to file FIR before the local police station. Now, this is one aspect of the matter. One part gets redressed. The other part is I wanted to protect my property by constructing a boundary wall with the police assistance. Now, that part remains. Now, with the ages of the special officer, that section 53 proceeding, we shall, as and when it will come up, we shall take appropriate steps.
Yes, that is a different issue, which is completely alien to this writ petition.
Kindly permit us to construct the boundary wall with the ages of the special officer and not the local police assistance.
But he needs to put it on affidavit. There is a direction by this court.
And so far as the special officer's remuneration, I leave it to the court's discretion.
Yes, at a time of disposal of the writ petition, I will take into consideration. Put it on affidavit, Mr. Dev. Next Monday.
Next Monday.
In the meantime, and kindly direct my lord to serve copies upon us also. The report of the case.
Report at present not necessary. If ultimately, if I pass any order for fixing responsibility upon the special officer to do certain thing, then appropriate direction should be given for supplying reports. Not today, next Monday.
Item number 6. My lord, item number 6, Mr. HON'BLE Chattopadhyay is representing the state, my lord. My lord, these are his medical documents, my lord. My lord, it has been already communicated to Landed Council Mojumdar, Mr. that he cannot come to court due to medical emergency, my lord. These are his medical documents.
Calculation
He has a serious case of cervical spine, my lord. Just for Mr. HON'BLE Chattopadhyay. For just today, he is on medical treatment, my
lord. Your lordship desired to have a look at the calculation. Sorry, if not, people don't understand how to hand over course. Judge last one. Judge last.
Amount refunded in 15 years, September 1999 to February 2010. That is not 15 years, Mr. Mojum, that is 11 years.
Should be 14. Should be 14. It at 10
Because petitioner retired on 28 February 1995. Why from 1999?
Not in his.
There was a revision of pension. That's
correct. The commutation, he received this commutation in 2 tranches. That's why.
In two
tranches.
But the 15 years commutation was not taken in one go.
It was not his superannuation was 1995.
Yes, yes.
But at one point of time, he was allowed 33% commutation. Thereafter, 40%. So in 2 tranches, he received this commuted value.
First, it was
33%. Then 40%. So at one point of time, 33%.
It was 32 to 40. Why change?
That was the state government policy enhancing the percentage of commuted value.
Now, when this 40% requirement was introduced?
But this was introduced in.
That is in my affidavit. 19.
I'll just take this. Now, these gentlemen got 33% commuted value of pension. Now, 15 years is countable from the date of superannuation, and the day on which he gets this commuted value of pension, from that date, this refunding starts. So that's why it's February 2010.
Whom follow?
I superannuated in 1995.
1995.
I got this commuted value in 1999.
So the commutation was made in 1999. Why not in 1995?
It's not given some amount, it's admitted position. Now this 15 years is counted from the date of superannuation.
So therefore, there was a superannuation, there was a commutation from September 1999, not from 1995.
But
in the case of the
this
petitioner
particular
number 42. Now there was a commutation for, that means there was a commutation for 11 years, not 15 years.
But it will be the same.
So why
process.
this was introduced later? So far the commutation is
might be he applied later on, or might be there was some problem, I don't know. But not, it's 1999 he has taken this, but this is done for, if it is from the first date of superannuation, this will be from the date of superannuation.
95.
95. Page 109 shows commuted.
Now in case of petitioner number 42, only 585 is to be restored.
Yes, but even after revision,
because it was prior to revision, this
even
amount
then,
of 1/3.
even then this remained the same. That's why the calculation is a straight figure.
Because the revision came after
10 years or 12 years, whatever.
So that the revision, the commutation was not on the basis of consolidated pension on revision.
No, it was the original.
Pre-revised, in the pre-revised
original superannuation.
That's why amount was less, 585. And now this amount is to be restored.
But when I commute, I restore at the rate of the commuted value, not at the revised rate. Now 15 years from the date of superannuation is the date for full restoration or refund. Now that's page 102 of the writ petition, 109 of the writ petition. That's the government memo. Now if your lordship takes the third serial number on that chart, normal pension amount would have been 1755.
Yes.
Now commuted 1/3 pension.
It came down to 1170.
1170. Now, when it was revised, the rate of refund remained the same at the rate of 585.
580. So now the requirement is 585 is to be restored.
But not in the process, out of a total commuted value of 64,233, I had refunded in 15 years of time 73,125.
15 years, 11 years.
That till the date of 15 years from superannuation, because it is countable from the date of superannuation. That's why it's mentioned like that. 73,125.
So when the when this deduction started, that is from September 1999, then it was given effective from 1995.
But maybe the rate is fixed like that. That means it's a permanent or a fixed rate, but not reckonable. 15 years reckonable from the date of superannuation.
Whether in effect petitioner had to refund the amount for a period of 15 years.
Not in effect in this case, no. But not it's refundable in 15 years time. Maybe this 585 would have been 525 then. Now, not as against
government or the authority made the one-time payment, reckoning superannuation from 1995, not for 11 years,
not for 11.
But from 15 years, lump sum payment was made. Yes. Now it had to be refunded within 15 years to be reckoned from the date of return.
Superannuation. So not as against 64,233, I refunded 73,125. No issue with that. But today, not by reason of non-restoration, I have already refunded 1,71,405.
Because this refund is going on. This refund is going on.
And this will continue till death.
On completion of 15 years, your pension would have been 11,407.
Yes.
But due to such refund 10,822, you are being paid
10,822.
10,822.
It's roughly because of the DR, not the dearness relief enhancement. There may be a few 100 or 200 rupees plus minus, but it is very difficult to calculate. But this is the
Mr. Talukdar, why this? How this can be countenanced?
Because
Because the very concept of commutation gets frustrated in this event.
my lord,
Suppose an employee is entitled to get 100 rupees pension. Now that has been brought down to rupees 70 for commutation. Now that the employee is required to refund within a period of 15 years. He refunded. Then what was his pension in that was 70, that needs to be restored to 100 rupees.
the difficulty
Otherwise, had the petitioner not opted for commutation, then he would have been paid 100 rupees for a period of 15 years and continue to get 100 rupees and the revised pension.
principally we were not against. And the documents annexed to the writ petition also, my lord has seen, my learned friend also placed, that time and again we have recommended. Why? In our regulation,
Government has paid for a period of, or the authority has paid for a period of 15 years. Refund, entered amount has been refunded within 15 years. Now, the employees are making further payment to the authority or the government, though 15 years has expired.
in our regulation, the provision for commutation is there, but there is no provision is there in our regulation for restoration. For restoration, there is no provision.
Can it be done?
That's the difficulty.
Not arbitrariness at its full flowering.
Had this thing had this thing being made known to the petitioners at the time of opting for commutation,
Yes, it was known. The regulation came in effect in 1988.
that for the rest of your life you have to refund the amount.
Yes, that is the DCRB.
How it was made known to them?
After introduction of this regulation, option was invited. Who wants to come under?
Yes, that had to be. That had to be. The option needs to be exercised. But once you enter into the cave, you will not be able to come out after 15 years. You don't know the method of coming out of the cave, whether that can be countenanced, that can be supported.
That is why when
Today, what is going on as it appears from these figures, court directed the petitioner to indicate these things in order to make the thing clear to the court. Things clear to the court. Now today it appears that the payment which was made by the authority, that has been refunded by the employee or petitioners. After the refund process is complete within a period of 15 years, now petitioners are making contribution to the state government, being pensioners.
Deduction is being continued.
Yes, how that can be
That is why
that can be supported.
Considering the request from the employees, my lord, time and again we have recommended the issue before the authority for allowing us to amend the regulation by adding one regulation to that. That was, my lord has seen that annexure P10, one of such case was decided.
I will read down the regulation.
Yes.
It's not even required, because not rule 52 at page 80 specifically provides that where the rules are silent, it will mutatis mutandis applicable to the or be coordinate to the state government rules. And the state government, the report of the state government says that the state government has its own pension rules which provide for restoration.
Madam, I shall answer this too. My learned friend has on the last occasion also submitted this. Today
on the medical ground,
these are the evidence documents.
It is the main creating main difficulty. Today there is a prayer for adjournment. Let the matter be heard. What can be done? It's a medical certificate.
And that fact that is not correct.
Mr. Mojumdar.
No, it's not required. Not he had spoken to me over telephone.
It is not a fact. We are enjoying.
When Mr. Chattopadhyay would be able to remain present before this
said
court.
that he
will
At
come.
the same time, also you have to appreciate that this is a case of the senior citizen.
My lord, it's a sensitive issue, my lord.
Yes. See the date of superannuation of petitioner number 42. 28 February 1995. So what is the present age of the petitioner number 42?
One thing, my lord.
My lord.
One thing, that we are enjoying the rest portion, it is not. I have
Yes.
submitted
Yes.
on earlier occasion also, that only the amount required, we get it from the government and
My lord,
reimburse.
2 days accommodation paid, ma'am.
Our
No,
Mr. Mojumdar, come back on Monday.
On
Great,
the
sir,
last occasion, your lordship desired the other order in 2011 writ petition to be produced, not just available on the net. This was only a direction.
Oh, that's whether the writ petition has been made available on record.
That we can't.
I directed the department to make available the writ petition. Is on record. Yes. Now, in terms of this order, the decision has been taken.
But probably so, but they have refused in that matter or not.
But the coordinate being proceeded on the premise there is a policy decision.
But the policy decision was for restoration. That's what. But I also seek not implementation of the policy decision through the aegis of the KMD DCRB rules.
Now it is a policy decision how the writ of mandamus.
So policy decision, not the state now has come through. Not policy decision can always be interfered with if it is found to be arbitrary. It's not that policy decision is inviolable. Not state has to justify its stand. Today the state in its report says that yes, we have in place the pension rules which provide for restoration. But these rules are under Article 309. It says that they say that there is a provision for restoration. My small point before this honorable court is when the KMDA DCRB rules provide for our mutatis mutandis application of the state government rules wherever the own rules of KMDA are silent, it requires no further deliberation. Rule 52 has two parts. The second part delves in a situation where it takes care of omnibus situations where the rules of the KMD or the establishment are silent.
State government rule
will mutatis mutandis apply. Not only rules but also orders and instructions. So if state government has in place a particular provision or order even an administrative order, not let alone the statutory, I mean the constitutional rules. Then also those are to be embedded or not imbibed in the provisions of the KMDA rules for the purpose of service conditions of the employees.
That we cannot implement because
But that's KMDA's understanding, not that's for the court to decide now.
this involves financial implication, and we are to depend on the grant received from the government.
But if some officer in KMDA,
No, it is true because last occasion also Mr. Majumdar pointed it out from the relevant part of the rules that the rule relating to restoration of commutation of pension is silent. Silent. So if it is silent, then the state government rule will be followed.
Since financial implications.
That's why straightway you could not implement. Matter was recommended to the state government. Now the state government is saying it has got
that. And pursuant to this order, the decision taken, that is perhaps annexure P10 is the order passed, which is annexed. There, my lord, we have made our position clear that we cannot bear the additional liability because the salary and allied expenses, the pension even, the pensions which are to be paid, my lord, we receive from the state and reimburse them.
Now, what is happening so far? The present pensioners are concerned.
Everybody is getting less.
I have got the written instruction.
But whoever has commuted, not he is contributing to the commuted value. Let me put it in this way: he is refunding apropos the commuted value.
We are not.
Where does where does this refund stop? Not state, in its administrative wisdom, decided that 15 years is the cutoff point of time by which this amount of commuted value should be restored.
Refunded.
And that's why each and every pensioner is refunding more than the commuted value up to 15th year. If he is getting 64,000 rupees at the time of superannuation towards commutation, he is refunding probably 73,000 or 75,000.
Why?
That's the calculation. It comes to like that on 15 years completion. So this is an additional burden which a pensioner opts for at the time of exercising his option towards commutation.
Then it is better not to have the pension commuted.
No, it's a one time. Everybody plans his life. It's a government order in place. Now, I'm not right.
This is the situation. Don't go for commutation.
Now, I'm not. One could not have foreseen that just because some officer might have acted, might have understood the rules in a different manner. But why should my normal pension not be restored at least prospectively now? One is a question of arrears. If KMDA is writing to the government for budgetary support, they should do so. That's an administrative wrong exercise of power.
And I have got written instruction from my office.
Now, today the government shakes its hands off. Today KMDA says, I don't have fund. And then in this manner.
What is the stand of the government in the affidavit?
Government says they are not government employees governed under the government rules. Therefore, I don't have anything to say. The government rules do not apply. Now, it is for the court to interpret the KMDA DCRB rules, which are once again state-framed rules, vis-a-vis the government's policies and that particular rule 52. But it does not appeal to anybody's logic commonly that one who has taken 64,000 rupees will continue to contribute till his death for 1 lakh, 2 lakhs or 3 lakhs of rupees. This is absolutely arbitrary.
Now, I want to see, I want to consider certain decisions, Mr. Majumdar, with regard to the policy decision where court, can interfere.
Not I can, the latest pronouncement of Supreme Court has not only gone beyond that policy decision, but also to the realm of contract, even if it is in contract of, an employment is a contract of employment, except for government service. I take my employment to be a contract of service vis-a-vis KMDA. The service rules provide for mutatis mutandis application of government rules or instructions wherever the rules are silent. And my submission is there is no specific requirement to inculcate this restoration on 15th year or whatsoever years. But even in the contractual field, I'll show the latest pronouncement of the Supreme Court in the anvil of Article 14. In the contractual field, your lordships in 226 jurisdiction can interfere. If it is arbitrary, and what is the meaning of arbitrary? It has been widely explained.
Place certain judgments because previously the coordinate bench has proceeded on the basis of a policy decision.
That policy decision was that government's decision to restore.
Now, government has taken decision not to restore.
No, the government policy is there to restore.
Yes, government policy regarding its
Don't
employees
employ.
restore.
No, government is not saying I don't restore, I don't say. I say that the government in its report says I have got nothing to say because they are your employees. KMDA says I don't have the fund. But they are required to send the requisition for this budgetary support then. In not doing so, they are doing a violation to their own rules.
For the purpose of making salary, payment of salary and the pension benefits of pension, you need to
every month,
place the requisition
Yes, every month,
for
every month.
allotment of fund.
After
And it is
receiving,
paid by the government.
it is paid by them.
Today it is not.
And we are
Today it is not gainsaying to submit that I send a smaller requisition, please some authority in the government, and then deprive these people.
And we are
Then
not
why
receiving
you did not, instead of since everything, the financial responsibility of the employees are on the shoulder of the indirectly are on the shoulder of the government, then why the KMDA took such steps, took such stand that after 15 years it is automatic. If you today, if you send a requisition of X amount, that will be paid by the government. The fund would be allotted by the government. If you send a requisition of Y amount, then that will also be considered and allotted by the government. So why this came to your mind? So far the KMDA is concerned that even after 15 years, there would be no restoration of commutation of commuted part of pension.
since there is no provision in the death cum retirement benefit.
It appears that you did the mischief.
That's right.
And may make the things complicated.
There is
And made the things complicated under service jurisprudence. How this stand can be supported?
That is why we wanted, my lord, to add one.
Because it
regulation.
depends upon sending requisition, monetary requisition to the state government for allotment of fund. Why this decision was taken? That an employee, he will be pitted against all odds after 15 years since the retired person has opted for commutation.
Since there is no provision regarding restoration,
Because the commutation after 15 years, after the entire amount is refunded, why a pensioner would get some pension at the lesser rate? At the lesser rate, why the less amount would be paid to the pension? Since one point of time he has opted for commutation. What is the reason behind this?
they are governed by this year.
And now we are saying at a time of restoration of commutation that the government has to take a decision. Why? You could have sent the requisition to the government.
In absence of any specific provision, we cannot. In our regulation, the CRB regulation, there is no provision for restoration.
But Rule 52 is amply clear, has made it abundantly clear that when there is no rule, when any issue is regarding any issue, rule is silent. The government rule will be followed. Then why this step, this stand was taken at the peril of the pensioners of your department?
On instruction, I submit in answer to this Miller, since
I could
for
understand
following
that you have forwarded the requisition by a separate head. You could have forwarded that this is the thing we have forwarded a requisition, and by giving a specific note explaining the situation. If in that event government would have rejected your claim or your requisition by on certain grounds, then I could understand.
No, that has
You made the mischief.
No, that has been, Miller, when we wanted to add one regulation regarding restoration, that prayer was rejected. That prayer was rejected by the government. Yes. That we.
But the problem is not the persons in the helm of affairs, they are government employees. They get their pension restored. So they have to be showing something, a rosy picture to the government.
And wants to be in the good book of the
government. The good books of the government. It's not so clear as it meets the eyes.
52.2 we cannot implement, Miller, because it involves financial implications.
That's the administrative
now it's a question of taking a decision. Now you show me that how the decision of the KMDA not to make the payment is supported under the service jurisprudence. That a person who is entitled to get 100 rupees, he has opted for commutation, got 70 rupees. for period of 15 years, refunded the lump sum amount paid by the government, and thereafter also he is entitled to get 70 rupees, not 100 rupees, or the revised term.
The only answer, my lord, that is
You explain the position that on what concept on the this stand is taken by the KM.
that we have in our affidavit also we have stated. There are documents in the writ petition also will show that we had time and again requested the government to that effect, and the government rejected them. Since we do not have the employees are governed by the 88 regulation, and the 88 regulation does not contain any provision for restoration of commuted portion of pension. That is why one regulation was required to be added, that we cannot, in view of 139 of the Town and Country Planning Act, we cannot, without prior approval of the government, we cannot make regulation. So we were not permitted.
The meaningful interpretation has to be attributed to the regulations. If the regulation is absurd, there is a absurdity in the regulation, then you have to consider these things.
That is, we framed this regulation in 1988 with the approval of the government in terms of the provision contained in the Town and Country Planning. That was approved. And this
Mr. Majumdar, on the next date, with regard to the policy decision and the contractual employment, the decision of the apex court, and when the court can interfere with the policy decision, you place certain judgments before this court for consideration.
Not one of the main grounds not where policy decision can be interfered with is if it is arbitrary, number one, number two, if it violates fundamental rights. Now, these are the two issues.
It appears to be arbitrary.
But our stand would make clear, from various documents annexed with the writ petition also, and in our affidavit. Plus, you will consider.
They will not. Why? After perusing the stand of KMDA,
after 15 years, this would have been automatic. This would have been automatic. This restoration of commutations would have been automatic.
That has been explained by the government that this is not allowable to the employees.
Because they sought for amendment of the regulation.
No, after that, this benefit is not cannot be extended to the employees of this development authority.
The writ petition is heard in presence of the learned advocates representing the petitioners and Kolkata Metropolitan Development Authority. Stop. Mr. Majumdar has placed before this court the statement placed before this court statement, the chart relating to payment of pension vis-a-vis the deduction made from the pension of the employee of KMDA for refund of lump sum amount paid to the retired employee. Under the scheme of commutation of pension. Next paragraph. During course of hearing, accommodation has been paid on behalf of the state respondents. Since the learned advocate representing the state respondents is unwell. Next paragraph. List the matter under the same heading for further consideration on. (22nd April 2020). Today's, sorry,
Today we are
29th
26.
April 2020.
7.
29th April 2020. Next Monday.
এইটা রাখো। হ্যাঁ তাই দেখাও তো একটু দেখো। Petition. ফার্স্ট লাইনই তো আছে, ঠিকই তো আছে। Mr. Mojumdar, you can leave. It's a separate issue.
Item number 7.
Lord, item number 7, I am appearing on behalf of the petitioner, my lord.
Okay. আগে সার্চ করা হয়েছে স্যার বললেন না ওকে
না, no, my lord.
Just I have served with the copy
No,
of
my
the.
lord, this is not a, my lord, right statement, my lord. The copy was served on 7th of February 2024. I have the acknowledgement letter, my lord. The copy is served, my lord, on 7th of February, 7th of March. No, my lord, very short point involved in this matter, my lord. My lord, a departmental report says that I was unauthorizedly absent from 21st June 2010 to 3rd February 2000, my lord, to 9th March 2011. A charge sheet was submitted. Now, my lord, in course of inquiry, no attendance register was produced, which is the primary document for proving the charge. That was not produced. Only on the basis of the statement of higher officials, I was, my lord, punished by the disciplinary authority. And more interestingly, my lord, the appellate authority passed an order of dies non for a period of 21st June 2010 to 3rd February 2014. That is the beyond of the charge period. This is, my lord, the nutshell, my lord, that this is about the two ground up challenge. Now, my lord, kindly come to page 22. My lord is not audible, my lord. My lord is not audible. Where is the wrong in the order of dismissal passed by the disciplinary authority?
No, my lord, there are two parts, my lord. First, if your lordship kindly consider the inquiry report which was submitted by the KMC, my lord. Kindly consider the inquiry report. That was, my lord, an affidavit shown by the KMC on.
Affidavit also preferred against this.
On 1st of December 2023. My lord, kindly come to the inquiry report. Lordship, kindly consider first the articles of charge.
Where is the inquiry report?
But it was submitted by the KMC by way of affidavit dated 1st December 2023.
Was earlier directed to him to produce, but he did not produce. Then
In the supplement.
No, it is the affidavit of report. Affidavit report. The affidavit report, it has been annexed, my lord. At page 11.
এই বাঁধো তো লেগেছে।
Namala, the question which I want to raise before your lordship, that whether a disciplinary authority can go beyond the charge sheet or not, my lord. That is the first point of my limb of my argument. The charge sheet says that I am unauthorized absent.
Page is the inquiry report, page 11.
Page 11.
Yes. Where is the drop inquiry report?
First, my lord, according to this inquiry report, the articles of charge lordship find that it is primarily the allegation against my lord the petitioner is that the petitioner was unauthorized absent from 21st June 2010 to 9th March 2011.
But since you have not questioned the inquiry report, how you can substantiate your case by writ petition?
By a leave granted, but because my lord, the
inquiry report was brought on record by way of an supplement, by way of an affidavit.
Because the inquiry report was not served upon me, my lord, first.
Meaning hereby, therefore it comes to the, it appears that the inquiry report was not questioned by the petitioner while challenging the order of dismissal. If inquiry report remains uncontroverted and if it is not disputed, then and if it is not questioned, then on what basis you can get an order for quashing or setting aside the order of punishment?
Now, my lord, in reply to that, my lord, first of all, my lord, the inquiry report was not served upon me. In course of hearing, my lord, the inquiry reports come from my lord, from the KMC, and pursuant to the leave granted by your lordship, my lord, I have submitted, my lord, the affidavit in exception to this inquiry report. I have filed an affidavit to that effect, my lord. That is already on record.
What point you have taken against this inquiry report?
My lord, I have 3 points. First, the articles of charge which says, my lord, that I am allegedly unauthorized absent since 21st June 2010 to 9th March 2011. But I was declared as the period of dies non is 21st June 2010 to 3rd February 2014. That is even beyond the articles of charge. Secondly, if your lordship kindly consider page 13 of the inquiry report.
Just a minute. You remained absent from 21st June 2010 to 9th March 2011.
This is allegedly, my lord, this is alleged by the disciplinary authority. For the argument's sake, kindly, my lord, kindly presume it is as correct. For argument's sake. Now, my lord, if your lordship kindly comes to page 40, the order of the appellate authority, that period which was declared as dies non is.
Why you remained absent during this period? 21st.
My lord, my case,
did you leave?
My lord, I tell your lordship, my lord, my case is that though I was present, but the attendance register was not available at that point of time, and that is the reason in inquiry report also, my lord.
Show me, show me any letter.
No, my lord, I tell you.
Show me any contemporaneous letter that you were attending your place of work, but no attendance register was made available to you, which
But I-
prevented the petitioner from putting signature on the attendance register.
my lord, I tell you, Lordship,
Where is that letter?
my lord, I don't have that letter. I don't have that letter, but
Then?
but my lord, kindly,
It's a Kolkata Municipal Corporation, and for this period from June to that means for a period of 9 months, attendance register was not made available to you.
now my lord, kindly consider one thing.
Answer the query of the court.
My lord, I don't have any letter, but this attendance,
this period of absence has been admitted by the petitioner.
no, my lord, I never admit that. I never admit that. But my lord, the attendance register was not produced before the disciplinary authority. Kindly come to page 13 of the inquiry report. Kindly come to page 13.
No, is it your explanation that the attendance register?
That is, my lord, I cannot.
You.
My lord, I cannot improve my case. Whatever is on the record, I have to argue that. But my lord, kindly come to page 13 of the inquiry report for my satisfaction. Kindly come to page 13. Page 13 of the inquiry report, my lord.
Yes, come to page 11 of the of the affidavit containing enclosing the inquiry report.
Yes, my lord.
Yes, part of the inquiry report, according to you, is unreasonable. No reasons have been assigned.
Now, my lord, the lordship, in case of unauthorized absence, the attendance register is the primary document. According to me, it was not readily available, and they said that yes, I was absent. Now, my lord, kindly
that you have prayed for supply of attendance register.
well, that later if I have that later, but I could have a very good case. But my lord, kindly come to page 13 once. Page 13 of the inquiry report. Kindly come to the page 13 of the inquiry report.
Yes.
The punishment inflicted only on the basis of the statement of two higher officials. Now kindly consider the paragraph at the mid portion. Now it would appear. Now it would appear from the above replies of the CO that his defense is simple denial of the charges and plea of innocence. But mere denial by the CO will not suffice to prove his innocence, for though the concerned attendance register has not been produced before me as evidence, nor it included in the annexure 3 of the charge sheet as evidence. Other documentary evidences on record have much force to prove his guilt. They are the materials on record weigh so heavily against him, even the absence of consent register. I consider them fully adequate to prove the charges against the CO beyond all reasonable doubt. In the background, simple denial of the charge. The few questions remain unexplained by the concerned CO. Now, my lord, kindly come. The next page, page 14.
Just a minute.
No, my lord, kindly come to the
Evidences adduced by Partho De, Sohili Mukherjee were taken into consideration. Did you pray for cross-examining those witnesses, prosecution witnesses?
My lord, from the inquiry report, I find I was not.
Now, what are the evidences adduced by the prosecution witnesses?
My lord, they are
The relevant part of the inquiry report.
my lord, that is on my lord page 12.
I'm sorry.
Page 12, my lord, find it.
You have ultimately you have been dismissed from service.
No, in the appellate authority, my lord, reverse the punishment, and the period was declared as dies non. But my lord, kindly consider the findings of the inquiry report.
Just a minute, I will consider everything.
Page 40, my appellate.
Where is the order of the appellate authority?
At page 40.
At page 40, my lord.
Where is the order of the disciplinary authority?
At page, my lord, 28.
Okay.
Now you have already retired from service.
Yes, my lord, I am retired.
When retired?
That
Yes.
But that particular date is not presently with me, my lord. Probably in my lord, 2018, my lord. That particular date is not with me, my lord.
You have not stated in the writ petition that when you have retired.
that my lord, no, my lord. Because my lord, I think my lord, while my lord, I have filed the writ petition is 2017. At that point of time, my lord, I was in service. Thereafter, my lord, I have retired.
So since the period from 21st June 2010 to 2nd of February 2014 was declared as dice non, therefore this period you did not get any benefit.
Yes, my lord.
So there it was shown as a break of service.
Yes, my lord. Now, my lord, primarily I'm raising the question.
Now come to the this chart sheet.
My lord. That is that, my lord.
Come to chart sheet at page, it starts from page 18.
Yes, my lord.
Is come to the relevant part, page 19.
Yes, my lord.
Read article of charges, statement of imputation at the middle, annexure 2.
Statement of imputation of misconduct and misbehavior in support of the article of charges framed against Sri Anup Chaudhary, Inspector under License Department, KMC. It is reportedly learned from the department report. Now, my lord, kindly pause, my lord. This department report has never been served upon me.
Please go on reading.
That Sri Anup Chaudhary, Inspector under License Department, has been absent from his duties with effect from 21st June 2010 without any prior intimation, permission from the competent authority. As such, one notice, 28 July 2010, following two show cause letters, 6th October and 16th November, were issued to him at his residential address as noted in the office record under registered post with AD. In the said note, Sri Chaudhary was directed to explain why no departmental action would be taken against him for such long unauthorized, and he was further instructed to resume his duties immediately. Despite issuance of these letters notices, Sri Chaudhary has neither joined his duties nor given any reply to the same to the department concerned, which causes serious dislocation of the office work civic services. Such conduct of Sri Chaudhary prima facie shows his lack of devotion to duty, insubordination, which conduct improper and unbecoming of a KMC employee.
Why you did not give any reply to these notices?
My lord, from the inquiry report, the statement is that no such notice was ever received.
Annexure 3 of the chart sheet.
Yes, my lord. The notices were there, my lord, but there is no ID card or my lord, postal receipt.
List of documents by which?
Yes, my lord.
Taken Sri Anup Kumar Chaudhary, Inspector under License Department, is proposed to be sustained. Then the note of Head Assistant, 3rd December. Then the note of License Officer, 6th February, December 2010. And the letter notice dated 28 July 2010. Then the show cause notices, so and so. And any other documents as may be required with prior intimation to the charged employees.
Kindly pause, my lord. Kindly
the relevant part of the inquiry report.
Yes, my lord. Before that, my lord, kindly pause. My lord, kindly pause, my lord.
The relevant part of the inquiry report.
My lord, kindly pause, my lord. Kindly pause for a moment.
Part of the inquiry report.
Yes, my lord. I am coming, my lord. But kindly pause for a moment. There is no postal.
Page 11.
Yes, my lord.
Read proceedings of inquiry. Page 11.
Before proceeding with the inquiry into the aforesaid searches, notices were issued to the charge sheeted officer, Sri Anup Kumar Chaudhary, and the PO, Sri Vivekananda Acharya, Sarvajana APO KMC, requesting them to appear before me in the preliminary hearing of the DP case against the CO fixed to be held on such and such in my chamber such and such. But even after issue of the said letter notices, which were sent to the CO under the registered post with AD, He did not join his duties during the concerned period or sent any reply to the KMC. The CO in cross-examination of the PW stated that he attended his duty on all the concerned days during the period in question. On 8th of February 2012, last hearing of the inquiry of the case was taken by me, in which both PO and Sri Vivekananda Acharya and the CO Sri Anup Kumar Chaudhary was present. In the first instance, the charged official was briefly examined by me in presence of PO to give me an opportunity to explain his position in regard charges against him. My question and replies are as follows. It is the fact that you absent from our office duties with effect from
Page you are reading, Mr. Bhattacharya?
page 13, my lord.
No, page 12 read it.
Page 12, my lord, I have read, my lord, already.
Please come to page 12.
Yes, my lord.
Started reading from page 11.
Sorry, my lord, I am extremely sorry, my lord.
You did not read page 12.
Yes, my lord. Yes, my lord.
Yes. That's why I could not find portions of the document which you are reading.
Yes, my lord.
Yes. Fixed to be held on 4th January 2012.
Yes, the PO Vivekananda Acharya Sarjan and CO Sri Anup Kumar Chaudhary were present. The
come to page 12, Kolkata, along with all necessary papers and documents for the hearing of the case.
Yes.
It was on 4th December. It was on 4th January 2012. Then please read.
In the first instance, the charges were read out to the charged official by the presenting officer.
Yes.
The charged official listened the charges attentively but denied them. It was therefore decided to hold regular hearing by calling the prosecution witness as per Annexure 4 of the charge sheet. In the next hearing held on 16 January 12, the presenting officer and the charged officials were present. Sri Partho, the head assistant license department, as listed as serial number 2 of the Annexure 4 of the charge sheet, was also appeared in the hearing as PW1. Before the PW1 was examined, the charge official, when asked by me, declined to engage any civic employee of his choice to assist him in the hearing. The charge official, on being asked by me, declined to inspect the document papers as listed in Annexure 3 of the charge sheet.
Then please pause here for a moment. Charge officer, on further being asked by me, declined to inspect or copy of the documents papers as listed in Annexure 3.
Yes.
Annexure 3 of the charge sheet.
Yes.
Yes. How do you respond to this? If the relevant documents of the note of the head assistant as well as note of the license officer headquarters are not perused and not controverted, then what is the wrong in coming to the conclusion against the charged officer?
No, my lord, here, my lord, just I want to submit, my lord, that in the Annexure 3, the relevant document, my lord, will find no postal receipt, not even any ID card.
Yes, please read the next line.
Then the POC Vivekananda Acharya Sarvajana examined the PW1 and his deposition was as follows. Yes, the note 3rd December 10 regarding unauthorized absence of Sri Anup Chaudhary is mine. I confirm that the facts stated therein are true and correct. He was unauthorized leave with effect from 21st June 2010 as mentioned in my aforesaid note. During the period of his unauthorized absence from duty, several notices were sent to Sri Chaudhary, but he did not attend his duties. He did not send any reply to the department. The charge official in his cross-examination of the PW denied all the charges as made by the PW in his statement. In the hearing held on 3rd February 2012, the presenting officer and charge official were present. Srimati Soheli Mukherjee, license officer, as listed in serial number 1 of the Annexure 4 of the charge sheet, also appeared in this hearing as PW2. He was examined by the PW Vivekananda Acharya, APO KMC, and her deposition were as follows. Yes, the fact mentioned in the note such and such, Sri Parthode, are true and correct. The order 6 December 2010, below the aforesaid note of the said head assistant is mine. Yes, it is the fact that the later notices and the 16 November 2010 were issued by the charge official over my signatures.
Yes.
But even after the issue of said letter notices which were sent to the charge official under the registered post with AD, he did not join his duties during the concerned period or sent any reply to the KMC. The charge official in his cross-examination of the PW stated that he attended his duties on all the concerned days during the period in question. On 8 February 2012, last hearing of the inquiry of the case was taken by me, in which both PO and Sri Vivekananda Acharya and the charge official Sri Anup Kumar Chaudhary were present. In the first instance, the charge officials were briefly examined by me in presence of PO to give him an opportunity to explain his position in regard to the charges against him. My question and his replies to them are quoted below. Is it a fact that you absented from the duties with effect from 21st June 2010 without any notice authorization from the competent authority? This is not true. It is a fact that several notices, letters were issued to you by the competent authority of the KMC under registered post with AD, but in spite of the same, you did not join your duties, thus hampering the civil service. Or no, all these charges are not true. Now, this is a very relevant, kindly mark this portion. Now, it would appear from the above replies of the charge official that his defense is simple denial of the charges and plea of innocence. But mere denial of the charges officials will not suffice to prove his innocence, for though the concerned attendance register has not been produced before me as evidence, nor it is included in the Annexure 3 of the charge sheet as evidence. Other documentary evidence on record have much force to prove his guilt. The materials on record weigh so heavily against him that even in the absence of concerned attendance register, I consider them fully adequate to prove the charges against the charge official beyond all reasonable doubt. In the background of the simple denial of the charges, a few questions remain unexplained by the charged official. For instance, if charges were really untrue, why should Head Assistant License Department initiate a false note as listed in serial number 1 of the Annexure 3 of the charge sheet regarding the continuous absence of the charge official from his official duties without any authorization from his competent authority, thus hampering the civil services, and submit the same to the license officer direct for her information and necessary action. Further, when the charge officer was all along present in the office during the concerned period of the case and presumably discharging his official duties properly, why should two such high-ranking officers as the charge as the license officer and the chief manager license KMC approve the false note of the head assistant Sri Partho De and sanction the disciplinary action against the charge official? This is impossible to believe that this is a case of frame-up against charge official and that such top officers of the KMC as aforesaid were enacting a plot to implicate charge official in a false case. Still further, there is nothing on the record to show when the notices, letters were sent to him over the. This kindly mark this portion also, my lord. Still further, there is nothing on record to show that when the notices and letters were sent to him over the signature of the license officer, KMC, he brought the fact to the notice of the concerned officer of his office that he was all along present in his office doing his official duties during the period concerned, and hence the notice letters issued to him was perverse, malicious, and hence malapide. However, after examining the charge official by me, the PO Sri Vivekananda Sarvajanno submitted me his written argument of the case, a copy of which handed over to CO. The PO's argument are quoted as below. Sir, as per the order of such and such, I have approved the presenting officer in the inquiry as per the article of charges, Anup Kumar Chaudhary, also without prior sanction, permission of the KMC, PW1, PW2 also confirmed his absent. As per my finding, after both parties' conversations, Anup Kumar Chaudhary, License Department, unfortunately violated the KMC rules by absenting himself for his duties. As such, I find the charges against him proved. I quite agree with the argument of the presenting officer that the charge officials violated the KMC rules by absenting himself from his duties without prior permission or authorization from the competent authority, and as such, I find
Mr. Ghosh, um, it is fact that there are certain documents which were supplied to the petitioner with regard to the note of the head assistant, then other officials of KMC supporting absence of the petitioner without unauthorized absence of the petitioner. Letters were sent, show cause notices were sent, but these documents remained not replied. As a result whereof, after giving opportunity to the petitioner to make deliberations before the inquiry officer, a finding was returned by the inquiry officer against the petitioner for imposition of punishment. Now, witnesses were examined, but the petitioner did not cross-examine those witnesses and did not also decline to inspect the relevant documents. Only thing which the Mr. Bhattacharya today is harping upon, that the attendance register of the relevant period was not supplied to him. Now, the inquiry officer, before the inquiry officer also, that though this attendance register was not placed, and the inquiry officer came to a finding that since other documents which were there as submitted by the which were there signed by the relevant officials, that is the head assistant and the concerned officers, which should be taken into consideration in order to come to a finding that it's a case of unauthorized absence. So therefore, attendance register, even if the same was not produced, that was found to be not fatal so far the proceeding was concerned. But come to page 29 of the writ petition, that is the relevant part of the order of the disciplinary authority.
Signature.
No, second paragraph.
Yes, second paragraph.
However, from the middle, however, from the certified copy of the attendance register dated 21st June 2010 to 2nd February 2014,
yes,
why this certified copy was not produced?
However, from the certified copy of the attendance register from 21st June to 21st February as well, from the notice of the note of the license officer found the charge officer was absent from certain period, and she truly continued to be signature in attendance register unauthorizedly from 10th March 2011 to 2nd February 2014 in the intermediate period. But he came and to be signature.
That certified copy, according to the petitioner, was not supplied to him. Attendance register. Now come to page 13 of your affidavit, which is the relevant part of the inquiry report.
Okay.
Now, at the middle, now it would appear from the above replies.
The charge officer
Of the charged officer.
and that his defense is a simple denial of the charges and the plea of innocence. But mere denial by the charge officer will not suffice to prove his innocence, for though the concerned attendance register has not been
Yes. Though the concerned, that is important, Mr. Ghosh. Though the concerned attendance register has not been produced before me.
Right.
Now, my query is that when the disciplinary authority, while passing the order of punishment, had the occasion to consider the attendance register, as it appears from page 29 of the writ petition, then why the same was not produced?
Page 29.
Yes. Page 29 of the writ petition. However, from the certified copy of the attendance register.
Yes, from certificate of the attendance from such period as well as from the note of the license officer.
Yes.
It is found that the charge officer was.
However, from the certified copy of the attendance register.
Yes.
So therefore, Joint Municipal Commissioner, being the disciplinary authority, had the occasion to consider the certified copy of the attendance register, but the same was not placed before the inquiry officer. Why?
Because of the reasons, that was the specific point he has taken before the Joint Municipal Commission when the second notice was given. that regarding the attendance register. That is the reason the attendance register was taken into consideration by the Joint Municipal Commissioner.
No, but he should have been given opportunity to consider the attendance register.
The attendance register, it was produced.
Very well, produce the attendance register before the court.
Because this was his case, it was not.
No. At least it's a case of unauthorized absence.
That's right.
So the first document which needs to be relied upon by the authority is the attendance register.
No, not only.
Now, why the note of the head assistant, note of the other officers were relied upon? Why the attendance register was not relied upon?
Because of the reason, it's a specific case that he intermediately came and put his signature by court.
So therefore,
That is the case.
that a copy of the attendance register should have been supplied to the petitioner.
That this is when this point was
I
taken.
could understand that attendance register was not available at the material point of time, but from the relevant part of the.
This is the attendance is there. It is the specific authorities.
But from the relevant part of the order of the disciplinary authority, it appears that attendance register was there. So why this was not supplied?
It was not. I do not know whether they specifically they asked for the attendance register. Attendance register was not before the inquiry officer. Now since he has taken a point before the disciplinary authority, that is the reason for the disciplinary authority looked into the attendance register. But the thing is not only that attendance is not sufficient, because whether he has been given any duty.
That should be the first document in order to prove the guilt. That should be the first document. So I could understand that attendance register may not be available. When the attendance register is available, why this copy of the attendance register was not supplied?
If somebody by way or other put his signature in the attendance register without my attendance.
And your inquiry officer is also saying that mere denial of charged officer will not suffice to prove his innocence, for though the concerned attendance register has not been produced before me.
No,
even before the inquiry officer, it was not produced.
I follow that point. The inquiry officer did not ask for the production of that attendance register. But when this point arose before the Joint Municipal Commissioner on his representation, that was taken into consideration.
Produce it before this court.
Right.
Let me see, because otherwise your inquiry is all right. I have seen, and the petitioner declined to inspect the relevant documents. And when the two prosecution witnesses were examined by the presenting officer, the charged officer, being the petitioner, did not pray for any leave to cross-examine those witnesses. These are all right. The exercise which was required to be carried out, that has been done. But what about why the attendance register was not supplied?
I definitely, it's available, I produce. That is the issue. But the attendance register putting my signature and standing at that point only,
the writ petition has been extensively heard in presence of the learned advocate. The writ petition has been extensively heard in presence of the learned advocates representing the petitioner and Kolkata Municipal Corporation. Stop. On placing reliance upon the charge sheet dated 8 June 2011, inquiry report prepared, inquiry report, and the order of punishment issued by the disciplinary authority dated 14th August 2014. It has been submitted by the learned advocate representing the petitioner that since the charge is unauthorized absence, from 21st June 2010 till 8 June 2011, the attendance register of the said period needs to be taken into consideration while arriving at the conclusion against the petitioner in the course of inquiry, in the course of departmental inquiry. Stop. Next paragraph, it appears from page 29 of the writ petition or এটা কেটে দাও। It appears from order dated 14th August 2014 issued by the disciplinary authority in order to impose punishment upon the petitioner. Certified copy of the attendance register from 21st June 2010 to 2nd February 2014 was taken into consideration. Stop. On the contrary, in the relevant part of the inquiry report, it has been recorded by the inquiry officer that the said officer did not have the opportunity to consider the attendance register. The said inquiry officer the said inquiry officer did not have the opportunity to consider the attendance register. Next paragraph. In view of aforesaid situation, the concerned authority of KMC is directed to produce the attendance register which was considered by the disciplinary the certified copy of the attendance register which was considered by the disciplinary authority while passing order of punishment dated 18th August 2014 on the next date. List the matter under the same heading for further consideration on Monday next, 20 on Monday week, Sixth May 2024.
My lord, only thing, my lordship, kindly take it up at 2 p.m. My lord. I will try to appear physically, my lord.
I do not fix any matter at any time. You won't find in my list 2 p.m., second 2 p.m.
No, my lord, but only my physical issues, my lord, I'm requesting, my lord.
What can be done, son?
My lord.
Try to be there online. If physically it would not be possible for you to appear before this court.
Yes, ma'am.
উপরে একটা করে দেবে যে লার্নেড অ্যাপিয়ার দেখবে একটা প্রথম সেন্টেন্স আছে দ্য পিটিশনার অ্যান্ড দ্য কলকাতা মিউনিসিপাল কর্পোরেশন আর রিপ্রেজেন্টেড বাই লার্নেড অ্যাডভোকেটস however the learned advocate representing the petitioner has entered appearance on virtual mode.
Item number 8.
May it please your lordship.
Madam, I am happy for the municipalities, madam.
Now, after going through the records and getting my memory refreshed, I submit that this is a war between two local bodies. And I am the victim of their war. I just show the affidavit of the both organization and the documents. Will you kindly turn to page 76.
Yes.
This is 9th July 2012 order addressed to the chairman, Haldia Development Authority. Now, I am just refreshing that I was given, my lord, the award by the Haldia municipality. That your lordship.
Lease. Lease.
Lease by the Haldia municipality.
That lease, this lease.
That lease is at page
36.
Yes. Kindly come to page 41.
31st day of March 31st March 2010.
Yes. Well, kindly come to the detailed lease by page 41. License. Deed of deed, form of license. And the relevant portion, my lord, is kindly come to page 45.
Then what is page 36?
Page 36, these are registered document I am placing. 36 note is the unregistered letter communication.
But page 36 is a lease deed.
But that was not registered, subsequently registered document.
So it is 5th October 2010.
Yes.
Yes.
And my lord has been pleased to notice, my lord, the terms and conditions and what are the purpose for which have given. Kindly come to, my lord, A, B, C, D. The license will pay 2,25,000 as yearly rent for the year 2010 to 2011, commencing from 1st of April.
Then which page you are reading, Mr. Bhattacharya?
I am reading the page 47. Page 47, these are the terms of lease.
Yes.
A, the license will pay 2,25,000 per year. I am just not rushing through without wasting my lord's time. The yearly license fee will be increased by 10% after each 3 years. Clause C.
Yes.
Then D, what are the obligations of the licensee? Licensee will submit a total and complete plan of beautification of the scheduled property to the licensor, that is the municipality. And after getting all its approval, will start the beautification work and other allied works. The licensee has to complete the entire beautification within 2 years, which was troubling both me and your lordship on the last occasion. What did I do? That's very important. Then what is licensee will be entitled to build up shade, building up to 2-storied and not to build any multi-storied building for the purpose of restaurant, shop, so and so. Then water supply system, electricity supply, these are the obligations. Then H is important. Licensee will be entitled to use the water of pond for pisciculture and gardening, but not for other use. But the pisciculture would be the source of income for the licensee. The gardening is only for the purpose of maintaining the beautification. Then kindly turn to next page. Clause M. After expiry of 30 years of this license, the licensee will automatically be determined. That is, it's a continuous license for 30 years subject to yearly license fee being paid. And in this event, the licensor will be absolute owner along with all rights, title, interest, possession of the all construction, trees, plants, so and so. On expiry of the license period, licensor may review the renewal of the license for subsequent period on satisfactory performance of the license. That before expiry of this agreement, the licensee shall duly carry out, perform, and observe all terms. These are the usual terms. Therefore, I can also come to I to अब बोला then kindly turn to the cause L. That is in fact the production of the next one. Then kindly turn to page 76. This is important. Rather, my lord, it would be better if I invite my lord's attention to page 72. This is addressed to the chairperson of Haldia municipality. Prayer for taking necessary and urgent action for the smooth running of development and beautification work in Shubha Sarovar. I, so Lordship may skip over that I was the highest bidder and its tender was accepted by the tender committee who decided to grant lease of the scheduled property for 30 years. I have also got the possession of the scheduled land from 31st March 2010. The deed of lease was registered on 5th of October 2010. After that, I have also got the total sanction for the planned development, so and so. Then during this period, I have also got the trade license. So I have started my scheduled development and beautification program and this continued. But this letter is of dated 9th of July 2012. But on 4th of June at 3 p.m., surprisingly, some officials from Haldia Development Authority, the clash begins because these two local bodies were headed by two different political dispensations. Municipality elected body by X and Haldia Development Authority nominated by government. The war started. The Haldia Development Authority, accompanied by police force, came to our premises where the development work was going on with a vast number of workers and ordered us to stop the work and say to produce all relevant papers to the authority of HDA. I have not any idea what is the legal locus standi of HDA in this development work, but as I ordered, I bound to stop the development work till then. Forget about the English, but you can get the idea. In these circumstances, I have got little puzzled. A total amount of rupees 2 crores are already invested by me for this project. So I humbly pray to you to make arrangement as early as possible from your end by which the development works can run smoothly. From 9th of July, in fact, from the 4th June 2012, this is stopped. Then I write to the Development Authority as well. Next page, page 74. Prayer for taking necessary and urgent action for the smooth running of development and beautification work. These are the scheduled work. I am not troubling my lord with that. Then kindly come to my lord the penultimate paragraph of this page. The deed of lease is registered on 5th of October 2010 in presence of additional district sub-registrar.
Which page? Page 75.
Page 74. The 74, the penultimate paragraph of the said letter, page.
Yes.
That is reference about the registered deed. Then again says, I have also got the sanction from the municipality. Then goes to that. So I have started my scheduled work. Then on 4th of June, third paragraph, some officials from Haldia Development Authority accompanied by police force.
Page 75.
Page 75.
Yes.
Came to our premises where the development work was going on rapidly with a vast number of workers and ordered us to stop the work. So I bound to stop the development work. I got puzzled. I humbly pray to you to make arrangement from your end. Letter is to the Chairman, Holdia Development Authority. To the address to the Chief Executive Officer, copy to Chairman. Then kindly come to the next page, page 76.
Yes.
Now, this is reiteration of the same letter addressed to CEO and to the Chairman. Then kindly come to page 78, letter dated 13th of August 2012, after that letter of mine. Now, Holdia Municipality writes to me. The authority has received your letter dated 9th of July regarding beautification work, as the matter is under sub judice. So you are requested to stop the development work till any further instruction from your end, from our end. Therefore, the municipality, my lord, by letter dated 13th of August 2012, following the footstep of Holdia Development Authority, asked me to stop the work. Naturally, I had no occasion to start the work. Then next page, on 28th of August, I write a letter to the Holdia Municipality. Please permit me to proceed. And repeatedly,
The undated letter.
that is, yes, my lord is absolutely right. I have also noticed, but the receipt shows the 28th of August 2012. These correspondences are going on. Therefore, Lord, I do not trouble my lord with that. Then kindly turn to page 82. The Holdia Municipality writes to me. This has reference to your letter dated 31st of August 2012. Holdia Municipality has been pleased to know that you are inclined to resume work in due compliance with terms of agreement. You are welcome to proceed accordingly, and you are required to complete all the projects within 3 months. But this letter comes, my lord, on the face of it when Holdia Development Authority, my lord, with police force stopped me from doing it. The municipality shifts the response on me that you carry on. Now, how could I carry on when there is a war between these two? Then kindly come to very interesting, page 89. That I reiterate all the things what I have said Millard before. Then kindly turn to page 90. The last but 2 paragraph of this said letter, page 90. Please note that if you fail to furnish the basis of your acquisition of Subhash Sarovar within 48 hours, I am unable to resume my work. Your statement regarding my authority to question the jurisdiction and control of the municipality over the Subhash Sarovar is without any substance. Whatever may be reason on your part to apprehend that I am being influenced by HDA, but it is unbecoming to think that I am acting as their pawn. Now the municipality and HDA, my lord, went on fighting. And the interesting part, my lord, that's my duty to tell your lordship, HDA, my lord, had filed an FIR against the chairperson of the municipality. Now that FIR was challenged by the chairperson before this court, and there's a reported judgment.
On what proposition, Mr. Wadage?
Because HDA, on the basis of this, that he have handed over this pawn to the Siraj Khan without any authority, they filed an FIR against the lady chairperson of the municipality. As I say, the fight between municipality and the HDA, that lady challenged the FIR, and this is the order passed by this High Court, staying the further proceedings on the FIR. But my status remains undecided. HDA doesn't permit me to continue with the work because of with police force, and the municipality feeling helpless that she was also facing an FIR, did not do any assistance to me to carry on with the work. If this is the background, Lord, for which I could not at all complete the work. Now see what is the stand of HDA and municipality vis-a-vis my position.
But Mr. Bhattacharya, this license agreement was made on 5th October 2010 on a condition of payment of rupees 2,25,000 lease rent per year. Now, this was paid by you for a period of 2 years. Now, all the communications with
all of 2012,
all are all of 2012. Ultimately, this order was passed. Termination order was passed by the Haldia municipality. Now, in the termination order, lease was terminated. Now, that was in 25th of October 2012. Now, irrespective of two warring authorities, a writ petition has been filed in 2016 on the premise that this water body is going to be settled in favor of
others, yes,
by issuance of tender license. Their termination order is also not under challenge. How do you reconcile this?
Milord, the termination order, Milord, is challenged to the extent that you cannot give it to the others because I have a continuity of 30 years. You say...
Please see the order prayer couched in the writ petition.
Lordship may take the different views where the prayers are concerned. Lordship need not be confined to the prayers. I am giving on the basic fact that you say that you could not complete it, terminate in 2 years. But you did not allow me to continue. Both of you are fighting. The HDA sent police to stop me.
Hey, we are in 2024. Now this
I am still in possession.
This lease agreement was made in October 5th, October 2010.
The delay in proceedings before the court
not only on the point of delay. You paid lease rent for a yearly lease rent for 2 years. That is from 2011 and 2012.
Yes.
Now, after that, how I can allow your prayer that would permit you to retain the water body in 2024 without paying lease rent for a further period of 12 years?
May I just answer very short. Milord, the lease rent has to be paid because of, Milord, the pisciculture and other beautification done. The lease rent I will not pay out of my own pocket. I will earn money and I'll pay you. You did not allow me by your legal force to...
Is it the condition in the lease agreement that on earning money I am to pay?
Milord, that is a force majeure clause. My lord, we don't have... My lord, the municipality, when entered into the agreement, did not think that the HDA will come and say stop it. This is the property of the whether HDA or municipality, would that be my concern? One authority under Article 12 issues, Milord, advertisement, I participate, I succeed. And I had a valid document. You do not permit me to continue. Even the municipality asked me, you stop work until further orders. Well,
and you took steps thereafter after 4 years.
No, but I just come to lordship. Now, in the meantime, what happened? This FIR, in FIR, I was also one of the accused. When the HDA filed an FIR against the chairperson, there I was made co-accused. Then I had to fight out this, the criminal case. The chairperson moved the Honorable High Court. I did not move the Honorable. I was facing before the jurisdictional court. And the Honorable High Court, after recording all these things, in 2012, 2000, the judgment was delivered in 2022 August. Was pleased to set aside this FIR, stay the FIR. It was not ultimately. Now the chairperson, after having died, the municipality has gone, the FIR goes, then only, I have the chance to approach your lordship. And I will show this, from the affidavit filed by the HDA, and you will find how this authority, proceeded, and how can a citizen who is, doing business can be made to suffer.
It's an area of 9.68 acres.
Yes.
Along with the water body.
Yes, water body remains under my control. I can't.
If I allow your writ petition, that would lead to a situation that you are permitted to retain the water body for a period of 12 years without paying any lease rent.
Without reaping any benefit. My payment will not.
And not only this, no specific challenge has been thrown to the termination of lease that was passed in 2012.
My lordship may, my lord, definitely ask me to answer about the lacuna in prayer. But lordship
Not
would
only the lacuna in prayer, the lacuna in the prayer, Mr. Bhattacharya, in an appropriate case can be filled up, can be cured rather. But how I can protect your interest, that would lead to a situation to retain the water body from 2012 to 2024 without any specific challenge to the termination order that was passed in 2012 and the writ petition was passed in 2014 on different premise.
Now, my lord, when I come to writ court, when my lord, the issue between the two authorities who is authorized,
I could understand that after issuance of this termination of lease, contemporaneously you have taken a step by filing a writ petition.
so that would have been an ideal situation. My lord, I cannot join issue there. That would have been an ideal situation. But my lord, we have to take, my lord, the whole factual aspect into consideration. Whether the municipality then has the power, my lord, to terminate at all. Because I was asking municipality that HDA says.
Understand, it is a case of a payment of pension to an employee. It is not that. It is based on a lease agreement. You have to enjoy a huge chunk of land.
No, I did not enjoy.
Water body, and the terms and terms of the lease agreement has not been adhered to.
Well, may I try to, my lord, persuade your lordship to dissuade from the idea that I have enjoyed. But admittedly, I was not allowed to enjoy. This is admitted both by HDA and municipality. Who stopped me? HDA, coming with police force. No, I did not know, I was not allowed to enjoy it. It remains as it is. But definitely, had I, my lord, carried on with the pisciculture, not paid, my lord, license fee, no, I would not answer to your lordship. That you have reaped benefit, you did not pay license. This is not a case that in spite of reaping benefit, you are not paying license. This is a
4 years delay would inure to your own benefit. That the court would, in a roundabout way, would permit you to retain this land for this land along with water body for a long period of time.
No, again, my lord probably is, my lord, having some sort of, my lord, idea on that I have enjoyed it. No, I did not, I could not enjoy it because of the both organizations will not fight. Now, I have shown your lordship who asked me to stop. They say, both municipality and DDA say, you stop it. You do not function, you do not beautify, do nothing. Well, I did nothing because of pressure. And that particular, my lord, water bodies remained stale. Only when, my lord, they issued a particular notification, wanted to hand it over to others, I approached the court. Now, definitely, my lord, it would include that this approach to the court, challenging the new tender would challenging the termination as well. Now, my lord, kindly see, my lord, the factual aspects of it. Kindly takes up the affidavit filed by the HDA. It will be amply clear that they were fighting with each other and I was made, my lord, scapegoat. But this affidavit needs to be placed in detail. This is by the Holdia Development Authority, Shuchandan Shamanto.
Yes.
Now, may I place it, my lord, paragraph wise? Kindly come to paragraph 4, subparagraph A. On 5th of August 1994, Holdia Development Authority, with a memo dated so and so, informed Holdia notified area, that is subsequently the municipality. Now, this is very important. This Holdia notified area is the municipality. Subsequently, notified areas are transferred to municipality. Like Salt Lake notified area, it was subsequent municipality. That possession of a water body named Subhash Sarovar along its entire embankment area so and so, under jurisdiction of Bhavanipur police station so and so, would be handed over to Holdia notified area for the purpose of beautification. This is admission by HDA. On 10th of August 1994, permissive possession of the said water body was handed over by Haldia Development Authority in favor of Haldia notified area, that's municipality, for the purpose of beautification and pisciculture for a period of 10 years. And a certificate to that effect was also issued on 10th of August 1994. It was recorded in the certificate that permissive possession of the said water body was handed over on lease basis for 10 years, and detailed terms and conditions shall be mentioned. Then it is pertinent to note that no formal lease deed was executed by Haldia Development Authority and Haldia Notified Area Authority, now the municipality. But am I responsible for that? The chairman of the Haldia municipality, with a letter number so-and-so, requested the chief executive officer of HDA to extend the lease period up to 2099 on the existing terms and conditions for taking up scheme for development and beautification of the said water body through a private party on the basis of comprehensive scheme. Pursuant to the request of Haldia municipality, with a letter dated 18th of May 2000, the board of HDA in its 66th board meeting held on 26th of May 2000 decided to grant lease of the said water body to Haldia municipality for a period till 2090. Copy of the relevant extract is annexed. Accordingly, the said decision of the board was duly communicated to the chairman Haldia municipality. Now, my lord, this is official handing over by the HDA to the municipality. Then they are taking a volte-face. Then in 67th board meeting held on so-and-so, it was decided that a lease of the said water body would be granted to Haldia municipality for the purpose of pisciculture and beautification. And a state committee of HDA was advised to finalize the terms and conditions of lease deed. But I'm skipping over, my lord, next two paragraphs. Then kindly come to, my lord, paragraph I, subparagraph I. It is pertinent to note that thereafter no formal lease deed was executed by and between Haldia Development Authority and Haldia municipality in respect of the water body. There was no authority granted by HDA under Haldia municipality had been holding the said water body. However, Haldia municipality invited a tender dated 11th of August 2009 for leasing out said water body for a period of 30 years on yearly rental basis for the purpose of beautification and commercial activities, which include activities such as boating, so-and-so, so-and-so, so-and-so. On 31st of March, Haldia municipality handed over the possession of the water body in favor of Siraj Khan, the sole proprietor of so-and-so, illegally, without any authority and permission from HDA. Chairperson Haldia municipality informed CEO HDA that with a memo dated 26th of May with a request to execute the draft lease agreement between HDA and municipality. From the said letter, it is evident that admittedly there was no existing lease between the Haldia municipality and HDA. Then ISO pipeline is an important M. Subparagraph M. CEO HDA with a memo dated so-and-so informed the chairperson Haldia municipality to immediately stop development activity adjacent to the pond in view of the safety and criticality of pipeline belonging to IOC. EO Haldia municipality with a memo so-and-so that the development activities had been stopped as advised by the CEO HDA and requested to take necessary steps so that the development activities can be started immediately. The CEO HDA with a memo so-and-so dated 1st November informed chairperson Haldia that the rent for use of water body will be rupees 2,000 per acre per annum, which will be enhanced by 5% every year. Therefore, this is on question of rent between the municipality and the HDA. The CEO HDA communicated to Chairman Haldia municipality on 3rd of May, informed regarding construction activity and prohibited construction activity, and to remove the construction done within a week. See, my all actions were negated by the HDA with the municipality's connivance or whatever it might be. Despite notice to stop development work, the work was not stopped. Wherein CEO HDA with a memo dated so-and-so informed OC Bhavanipur Police Station, Puru Vindapur, to take necessary action to stop construction and take necessary police action against the agency and the Haldia municipality. EO Haldia municipality with a memo issued notice inviting interested persons for angling in Subhash Sarovar for the period so-and-so. CEO HDA with a memo dated so-and-so requested EO Haldia municipality to withdraw the notice of angling and to stop any activity carried out by the Haldia municipality over Subhash Sarovar on the grounds that no lease deed has been signed with Haldia municipality for utilized paid water bodies. Then HDA lodged criminal complaint against chairperson Haldia municipality, which was challenged by the chairperson Haldia municipality in a writ petition being so and so. This writ petition was dismissed. Again, there was a misstatement of facts by an authority, is very unfortunate. It was dismissed when the lady expired. And in the meantime, the interim order was even enjoyed. I have handed over the copy of the interim order. The authorities should come out in clean hand. Anyway, this is done. Then HDA invited tender so and so on 5th of February 2016 for leasing out the said water body. Therefore, this 5th February 2016 till then, the situation was so that the Siraj Khan Milord could not do anything but was sitting idle. When this 2016 the tender was invited by the HDA, the petition was filed. The board of HDA accepted the proposal of the municipality to execute a fresh lease deed with Haldia municipality for leasing out the said water body to Haldia municipality for a period of 5 years on receipt of total payment of so and so. Therefore, again, my lord, after these criminal cases and the lady expired, HDA had understanding with the Haldia municipality and they permitted it. CEO HDA suspended the notice of tender. Then again, CEO HDA, paragraph Y, dated 22nd of March 16, informed Chairman Haldia Municipality that the board of HDA has decided to grant lease of the said water body for 5 years for pisciculture against a lease premium of so and so. Chairman Haldia Municipality, memo number so and so, hand over the possession of Subhash Sarovar together with allied land and assured to extend all endeavors to withdraw the present petition filed by Siraj Khan, proprietor of Siraj Khan Fisheries. Therefore, my lord, they are trying to negotiate with Siraj Khan, and that negotiation failed. But all these actions, my lord, if your lordship were taken from a practical point of view of a businessman, that what would come? That both of the authorities felt that Siraj Khan became victim, therefore it should be done on negotiation. Then CEO HDA, by a letter dated 20th November, informed Chairman Haldia Municipality regarding the pendency of a writ petition regarding subject of granting lease of Subhash Sarovar by Haldia Municipality and requested to take steps for resolution of the same. Then Haldia Municipality executed a lease of agreement with a private party even while no lease deed between agreement had been signed between Haldia and the HDA. For that I am not responsible. Possessive permission has been provided for the purpose of beautification and pisciculture, whereas in Haldia municipality invited tender for carrying out commercial activities such as boating, angling, so and so. Haldia municipality carried out development work despite no agreement being signed and registered between municipality and HDA. Haldia municipality continued to carry out development work in spite of assurance to stop work pursuant to objection of IOCL. Now, this is the background situation. The others are all technicalities, legalities. I am not on that. My question is not what would be the position of a businessman who had invested money on the basis of invitation by an appropriate authority. And that I am out of court if they can show that the work was stopped at my instance. Number one. Number two, that I had reaped the benefit out of that and then did not pay the lease rent. If these two conditions are prima facie is being satisfactory to the court, of course, the court will say you have no right because you did not discharge your obligation. Now, this is the affidavit of HDA. Now, kindly takes up the affidavit of the municipality. What would the common man do?
Come to the prayer of the writ petition. Please come.
Yes, I'm coming to. Well, kindly see the writ petition's prayer.
Page 27.
Yes.
Prayer A is not relevant.
May I try to explain the prayers and seek my lord's kind exercise of jurisdiction, my lord, that in a writ court can mold the prayer as well. Now, B, issue a writ in the nature of mandamus, commanding responding authorities to cancel, set aside, quash, revoke the impugned tender, notice dated so and so. Then issue a writ mandamus directing the responding authorities to allow the petitioner to continue and complete the development work and beautification on the basis of the deed of lease so and so. Well, this prayer, if your lordship, my lord, allows me to interpret, it would include, my lord, the setting aside of the termination.
Now, in the pleading, whether any statement or any ground has been taken against the termination of lease,
My lord, directly no.
then I could understand.
My lord,
That any pleading point has been taken.
my lord, of course, my lord, I could not, my lord, find such a specific pleading.
Court would not stick to the prayer made couched in the writ petition,
Hmm.
provided in the pleading this material.
Right, that's the law. Well, I will not join issue there. But again, well, at the risk of repetition against going against my own habit, I would say the my lord will have to, my lord, look into the entire gamut of facts arising out of a fight between two authorities and a businessman who has invested money. Or would he get back his money today? But now Supreme Court has gone to a great extent saying that even Article 14 is applicable even to the commercial business terms also. I had spent my money. I could not get back my money by utilizing the property. Both of you are fighting. Might be that there was a formal letter of termination, which is not really challenged in truest sense. But as a fact, this is the challenge, my lord, and praying that I should be allowed to continue on the basis of the lease deed, original lease deed. But when I pray this, again, my lord, this is of course at the discretion of the court, that whether the court will grant that the intention was to carry on the basis of the original lease deed, ignoring the termination. And that, my lord, will kindly take note of not the fight between the two organizations. That's why I'm placing this. Now kindly takes up the affidavit of municipality. How they have put this person in trouble. And both of them should jointly, my lord, then compensate me. Kindly takes up the affidavit of municipality September 28, 2021.
Yes. Affidavit of the municipality.
Yes. I submit that the said application.
Just a minute, Mr. Gordon.
I don't find how funny the stand of the municipality is.
By one Pritam Das.
Yes.
Yes.
Paragraph 2. Before dealing with the said application, paragraph wise, I submit that the application is liable to be dismissed on the ground. Kindly note this. Of violation of deed of lease executed on 5th day of 2010 in between Haldia Municipality and Siraj Khan.
Which paragraph you are reading? Paragraph?
Paragraph 2.
2. Has it been affirmed on 16th February 2024?
Affirmed on 28th September 2021. 28th September. I filed one.
দুটো file করেছে?
Appropriate order file করেছে, application for appropriate
Oh.
order.
Well, I am told one is an application for appropriate order. Lordship will kindly set those documents apart.
Last one একটা রিপোর্ট সাবমিট করতে বলেছেন স্যার, সেটা ফাইল করেছিলাম। এটা আপনার 16th February 2024 last one.
Have you filed it in the department?
No, no, madam. I'm filing in court.
দেখে দিন না যশোর ফাইলটা নিয়ে। Haldia municipality. Affirmed by
the notary public.
Affirmed by Pritam Das. Dated September.
সম্পদ সরকারি কোর্টে বেঁধে হয়েছিল।
এখানে দিন হাসান খুঁজে দেবে দিন হাসান খুঁজে দাও দেখে দে না একটু গিয়ে COVID-10. Oh, I see.
Yes.
Well, can you come to paragraph 2? I submit that the application is liable to be dismissed on the ground of violation of deed of lease executed on 5th day of October 2010 in between Haldia Municipality and Siraj Khan, but the petitioner could not satisfactorily, kindly note this, petitioner could not satisfactorily proceed with the job as per agreement dated so and so. He prayed for taking necessary action to start the development and beautification work in Subhash Sarovar. Though the development work was started from May 2010 as per his own admission, the municipality, out of his grace, asked the petitioner to resume the work and complete the same within a period of 3 months by the letter dated so and so. But in reply of the said letter, the petitioner by his letter dated so and so expressed his unwillingness to complete the project on various frivolous grounds. What was the ground? I said the HG has stopped me. You take appropriate action. Now say this is the ground which is frivolous. Where the petitioner is bound by the agreement of license entered on 5th of October, and also the petitioner has not paid any rent till date, which is clear violation of the deed of lease dated so and so. For that, Haldia Municipality issued a letter dated 5th October 2012, the petitioner for termination of the agreement dated so and so to the beautification Subhash Sarovar, because the petitioner did not complete the project. Now, my lord, after having seen the letters I have placed before your lordship, the municipality says that you did not do it on his own. And while Haldia Development Authority in their affidavit says the municipality had no authority to issue this license. Where do I stand? Haldia Authority says, admittedly, we had asked the police to stop it. No construction could be carried on.
Where is that letter of the Haldia Development Authority annexed to the writ petition?
Yes, you will kindly come to page 76. No, sorry, that is my letter.
There's a one letter of the Haldia Municipality.
Yes, yeah. Look, page 78 is the letter of 13th August by the Haldia Municipality. The authority has received your letter dated so and so regarding
Sub judice.
Yes, sub judice. And now they say that you did not proceed. And therefore you have violated. And HDA Milot in his affidavit very categorically says that you have asked.
HDA has issued any letter to you asking you not to carry on your work?
Yes, yes. Look, that is very clear from the HDA affidavit itself.
Yes, but any letter, no letter has been issued.
Yes. Yes. We kindly turn to affidavit of the HDA. This is letter by the chief HDA to the municipality. And pursuant thereto, the municipality will ask me to stop it. Page 41.
Of the writ petition? The affidavit.
Page 40. Rather, it's from page 40.
Of the affidavit of
opposition of HDA.
HDA.
And 42 letter to the OC concerned. Stop these illegal constructions. And vis-a-vis my letters of 9th of July 2012, both to the HDA and to the chairman and the municipality. মাথা লাগছে তো টুপি পড়া একটু বই নিয়ে পড়ি আমি ঠিক টাইম নিয়ে মুখটা ঘুরেছি দেখার জন্য মাথা লাগছে
Where is that letter since the issue is sub judice?
That is not page 77, 78. Yes. Now, kindly, along with this, will also kind of takes the trouble to once again come back to the HDA's affidavit, where the HDA says that we want to get it settled through negotiation with Siraj Khan. Subparagraph Z, page 10.
Subparagraph
Z.
of the HDA, affidavit of HDA.
But the HDA's affidavit is very important. But the municipality has nothing to do except saying that we have asked him to complete the work.
Yes.
But in this background, I will not trouble my lord much with the other facts. My lord, you have to take, my lord, this broader aspect into mind that the tradesman, a businessman, he is not at fault. Because of war between two statutory authorities, he was made victim. He should not be penalized. That he should be allowed either to work or reach benefit, fetch benefit from that. Their project of beautification has not been abandoned. This project is still there. They might have modified the project for the purpose of ego satisfaction. That's their business. But the pisciculture and the other purpose for which it was leased out, that I cannot be deprived of. These are my submission.
Lord, my first submission before Lordship, my lord. The lease was executed on 5th October, my lord, 2010. On 5th October 2010, the lease was executed with petitioner and with Haldia municipality. My lord, pursuant to the lease agreement, that work will be completed within 2 years. But he has not completed that work. He has paid the.
Where is that relevant part of that?
Yes, yes, ma'am. Yes. Second, my lord, I'm. My lord, page number 48, subpara 8. I'm reading, my lord.
Just it. Yes.
My lord, he has started work, but he has not completed. In the meantime, my lord, one FIR was lodged by the CO HDA against the chairperson of the municipality. My landlord senior moved this petition and got the order to cause the FIR. On the time, my lord, we had issued a letter. The matter is sub judice, therefore you stop the entire work. On dated annexure P9, page 78. Thereafter, my lord, on 5th October 2010, page 87, P14, my lord. On the last paragraph, you also can see page number 88. Relevant portion is page 88, my lord. But I'm reading, my lord.
Page 88.
Page 88, my lord.
It's a termination order.
My lord, within 48 hours,
Now
you are not started.
You send a letter,
my lord,
page 78,
my
that as the matter is sub judice, so you are requested to stop development work.
Yes, my lord.
That is due to pendency of the writ petition challenging
It is
initiation
not
of,
writ petition, my lord.
initiation of proceedings against the chairman of the Haldia municipality.
Chairperson of the municipality, yes.
Now, that is 13th August 2012. And thereafter on 6th September 2012, you are against, you again issued a letter to the petitioner that within 3 months you complete your work.
At 6th September, we are issued a letter.
Page 82.
Page 82, my lord. In the meantime, my lord, that
so why
petition,
this two different stand has been taken into in the month of August and September?
But as because the petition was, the FIR was stayed by the Honorable High Court. My landlord senior moved with this petition on the time. Thereafter, my lord, we had issued a letter to start the work, to complete the work within 48 hours. Otherwise, your lease will be terminated.
Where is that letter?
My lord, that letter is here, my lord, page number 87. Start from page 87. And the living portion is page 88, my lord. The agreement with you entered into for the beautification of Subhash Sarovar will, however, stand.
Page 87, you are reading from page 87?
My lord, page 88. Last portion.
That is after the order passed by the writ court in connection with the writ petition filed by the chairman Haldia
municipality. Thereafter, my lord, the petitioner paid 3 terms of the lease rent, my lord.
But the final order was passed on 22nd August 2012.
My lord. Thereafter, my lord, the petitioner submitted the three terms of lease rent, 2010, 11, and 12. From 2012 to 2016, he has not paid any amount. For 12 to 16, he has not paid any amount. Thereafter, my lord, petitioner moved one petition before the Honorable Court, and my senior got interim order. That interim order is continued till today. In the meantime, my lord, on the last occasion, your lordship was pleased to direct me to file an application, whether I am entitled or not to lease out the water body. I am submitted one application, your lordship can
that I have seen, yes.
My lord. Deed was not executed, but several times the Haldia Development Authority communicated a letter that your lease will be extended up to 2090 and also 2099 also. We had communicated 2 letters, kindly send the draft copy, but they are keep silent. Again, till today. Now, my lord, the petitioner Several times we are communicated a letter to the petitioner to start to work, start work. He has not started the work, and he are enjoying the interim order, my lord. We are losing money. Since
What interim order was passed on this?
on 2016, my lord.
What was the what was that order?
Until further order. The interim order continue until further order. You'll also kindly see the order is here. My lord, order is 2nd March 2016. My lord is moving the petition before my lord Mr. Justice I.P. Mukherjee, and that interim order is continue. So that we are losing, and not only that, my lord, that water body is now a health hazard, and mosquito is born, and too much unhealthy condition till today. He has not possession, and he has not maintenance the water body, and this is the situation, my lord.
Yes. Development Authority.
My lord.
Yes.
First of all, the writ petition is infraction. The writ petitioner has challenged the tender which has been
Use microphone.
My lord, first of all, the writ petition is infructuous. The writ petitioner has challenged the tender which has been floated by Haldia Development Authority in 2016. My lord, the tender was valid for 2 years. So as on date, that there is no tender, the tender has lapsed. So as on date, the writ petition has become infructuous. Secondly, my lord, the termination. The termination in the writ petition which has not been challenged by the writ petitioner. Third and most important, my lord, under what authority the HDA, the Haldia municipality, has executed a lease deed with the writ petitioner. My lord, the initial period of lease which was extended to the Haldia municipality was up to 2004. After 2004, there was no formal lease deed executed. It was in the 66th meeting. It was decided that a lease deed will be executed, which will be extended for such and such.
How the petitioner is supposed to know all these things?
My lord, the petitioner is aggrieved if the petitioner is aggrieved, the petitioner's grievance is with the Haldia Development Authority, with the Haldia municipality. The land belongs to the Haldia Development Authority. He cannot come and say that as a lease has been entered into by the Haldia municipality, he will be permitted to continue with the lease deed. And as on date, whether the lease deed is a valid lease deed, whether Haldia municipality has the authority to enter into a lease deed for beautification of the Sarovar with a third person. It is the Haldia Development Authority who has the right to enter into a lease deed.
According to you, that lease deed was valid till 2004, which was the lease deed which was executed in favor of municipality.
Municipality. That is
on the date of executing lease deed in favor of the petitioner,
there was no
municipality was
no authority was given to the Haldia municipality to enter into any lease deed for beautification of the land. Thirdly, the writ petitioner's grievance is the damage which has been caused to the writ petitioner for entering into the lease deed by the Haldia municipality with the petitioner. That can be adjudicated before another forum if he has any damage.
Yes.
That's all.
Mr. Bhattacharya, would you like to give any reply?
I would just like to reply. Kindly come to the Haldia municipality's termination letter. Mr. Hassan Miller has said something which is not correct to the fact. But the agreement was at page 87.
5th October 2010.
Yes, very, very important. Now, he has now, after hearing my argument, takes the plea of the order of the division. High Court, it was expired on delivered on August. See what is the stand. You, however, could not satisfactorily proceed with the job as per agreement. It appears that by a letter dated 28th of August, you have prayed for taking necessary action to start the development and beautification work in Sarovar, though the development work was started from May 10 as per your own admission. This is with regard to start. You are also by letter dated 9th of July 12 informed that some people from Holdia Development Authority with the assistance of police forcefully stopped your operation. Even this is the stand of Holdia today. Though the HDA had no legal authority to ask you to stop working on the project, yet for the reasons best known to you, stopped working. They've admitted that I had to stop because of the HDA. Municipality, in a bid to assist you and to restore your confidence, also had asked you by letters dated 30th August to stop the further work. Municipality to assist me, asked me to stop the work. Then the municipality, out of its grace, asked you to resume the work and complete the same. It does not say that the municipality has the legal authority. Staying of FIR doesn't give them the municipal authority with regard to the ownership of this sort of work, which HDA is putting a stop on me. And then say, in reply to the direction, the municipality, you by your letter dated 24th September expressed your unwillingness to complete the project. You are bound by the agreement of license entered. You have no authority to question the jurisdiction and control of the municipality over the Shubhashar work, which the HDA is putting me. The municipality have reasons to believe that you are being influenced by HDA to act as their pawn. The municipality is considered opinion that you are unwilling to complete the work in terms of agreement. The agreement which you entered for beautification will, however, stand terminated in the event you fail to resume the work in 48 hours. How could I resume? When HDA comes and says you cannot run it, this is my property.
But the license has been given to you. Lease has been executed in your favor.
That's my point. The one agency says, I give you license, other agency says you do not work. You cannot work. I stop it at fully sports. What do I do?
Now, when the municipality requested you to start your work, what was the difficulty in starting?
The HDA is putting stop on me. HDA will not enforce police. HDA comes and said with the police, because that's the affidavit, you stop work, otherwise you'll be arrested.
Where is that affidavit?
Yes, that's affidavit HDA.
You physically prevented the petitioner
Yes.
from
Kindly come to the affidavit
executing
HDA.
the work? Yes.
HDA's affidavit.
Affidavit of HDA, yes.
Yes. They have lodged an FIR also. Kindly come to Milord P and Q. Page 7. CEO HDA communicated to Chairman Haldia Municipality with a memo dated 3rd of May, informed regarding construction activity and prohibited the construction activity and to remove the construction done within a week. Despite notice to stop the development work, the work was not stopped. Wherein CEO HDA with a memo so informed the OC Bhavanipur Police Station, Purva Bindapur, to take necessary action to stop the construction and to take necessary police action against the agency and the whole municipality. Therefore, I was forcefully stopped by one agency. I cannot go on and break my head with the police. And admittedly, today, Milord, the submission of municipality is that this is not being properly cultured. Therefore, the mosquitoes are breeding over there. Therefore, you stop me from doing anything. How could I do? The lack of the petitioner's pleading and the prayer, Milord, would not develop the ground real situation.
What was the situation from 2010 to 2012?
Stop work. But
as is in 2012.
Yes, but I had constructed.
But the lease deed was executed on 5th of October 2010.
I had continued work
to complete work within 2 years. Now, what was going on in 2010-11?
I have proceeded with. I have conducted. I have paid lease fees. But till I was,
You have paid lease fees, but what progress was made with regard to the beautification?
yes, I had all beautification, construction made, pisciculture was going on. That's why they say,
Where is the statement in the affidavit, writ petition?
the need petition lordship kindly sees, and that is also apparent from the affidavit itself. The construction was done.
Show me
stopped.
that you have made a considerable progress in the beautification work
Yes, I have said so. Just let me,
during 2010,
Yes,
11
yes.
and 12.
You kindly come to page, paragraph 10. Your petitioner states that all of a sudden, the Haldia Development Authority accompanied the police force came to the premises wherein the development work by the petitioner was taking place with a vast number of workers. The said officials of HDA ordered the petitioner and his workers stop work and demanded the petitioner to produce all relevant papers before the HDA. As a result, the petitioner was bound to stop the development work of Suhas Sarovar.
For June 2012 incident.
Yes.
But what was the incident? What was the difficulty in carrying out work in 2011?
That we had carried out. No, there was a complaint.
Where you have made statement
Yes,
in your
yes,
affidavit.
I am placing it.
Yes.
It is further stated that the petitioner made a represent the authorities on Swans very entirely. He narrated development incident in detail. In the said representative, it was also stated that petitioner has already invested total amount of rupees 2 crore in the project. That the petitioner made a prayer for an arrangement so that the development work could run smoothly at the earliest. Therefore, this is the investment I made. And but there is no iota of allegation that till I was stopped, there was no work. On the contrary,
I want to.
I follow my query. That's why I say the lack of pleading would not do. The factum remains, till I was stopped, there was no controversy. Neither the controversy with regard to that you are not carrying out the development work, nor that you are paying the rent. The controversy came when HDS stopped me with police force. And the municipality ultimately became absolutely bystander because of the FIR against the chairperson. This is the reality. And to that extent, Lordship would be kind enough to a citizen who is in business legally cannot be deprived of his right. And that too, there is no dispute that this statement that 2 crores was invested has been made. None has disputed that. The municipality has never said that you started work, but you did not do anything. You started work, I asked you to stop it, you stopped it. That's the point.
Yes.
I have deep love that note.
Yes. The writ petition has been filed, inter alia, challenging tender notice dated 5th February 2016, issued by the Haldia Development Authority, within bracket hereinafter referred to as HDA, close bracket, HDA, hereinafter referred to HDA, within bracket. Now, referred to, hereinafter referred to as HDA, close bracket, in connection with an water body, in connection with a land and water body measuring 9.68 acres. And prayer was made to issue a writ of mandamus in order to permit the petitioner to continue and complete developmental and beautification work at the land in question, containing having an water body named Suhas Sarovar. Stop. Mr. Bikash Ranjan Bhattacharya, learned senior advocate, submits on behalf of the petitioner that a lease deed was executed on 5th October 2010 in between Haldia municipality and the petitioner. For a period of 30 years on payment of lease rent at the rate of rupees 2,25,000 per year. Stop. It is submitted on behalf of the petitioner that the petitioner was prevented from carrying out beautification work at Subhash Sarovar within the time stipulated in the lease deed, in the aforesaid lease deed, in view of due to intervention of the Haldia due to intervention of HDA as it emanates from paragraph 4 within bracket Q of the affidavit in opposition used on behalf of HDA. The notice of the notice of this court has been drawn to the incident as narrated in the said paragraph. Due to failure to prevent the petitioner to stop work, with a memo dated 4th July 2012, officer in charge of the concerned police station was directed to take necessary action for to stop construction and police authority was also requested to take steps against Haldia municipality. Main limb of submission as advanced on behalf of the petitioner is acrimony in between HDA and Haldia municipality, and the petitioner was victim of the same. It is It is also submitted that the petitioner put in lease rent for a period of 2 years, and thereafter, since he was prevented from carrying out work as he was required to perform in terms of the lease agreement, he made he preferred letters to the concerned authorities of Haldia municipality on different dates in the year 2012. কি সেন্টেন্সটা বলছিলাম? বলো। From one of such letters dated 9 July 2012, it appears that the work which was being carried out by the petitioner in the month of June 2012 was obstructed at the instance of HDA due to deployment of police authority, due to intervention of the police authorities, based on complaint made by the HDA before the state police authority. This information, as it was disseminated, it was supplied to the Haldia municipality, is also echoed from other letters, similar letters issued by the petitioner in the year 2012, which, according to the petitioner, is the reason for his inability to complete the work within the specified time. Stop. Different the statements made on behalf of HDA in different paragraphs of affidavit in opposition are also placed before this court in order to point out that there was differences in between HDA and Haldia municipality, which led to a situation where FIR was lodged against the chairman of the municipality at the instance of Haldia Development Authority, triggering a writ petition being WPA 17087 of 2012. Stop. However, it has been submitted that the writ petition preferred by the chairman of the municipality was allowed by the coordinate bench vide order dated 22nd August 2012. As a result whereof, a letter was issued on 6 September 2012 on behalf of the municipality addressed to the petitioner to complete the project work within a period of 3 months. However, prior to that, during pendency of the aforesaid writ petition, a letter dated 13th August 2012 was issued on behalf of the municipality asking the petitioner to stop the work due to pendency of the aforesaid writ petition. Next paragraph. Relating to issuance of termination letter dated 5th October 2012 issued on behalf of Haldia municipality, whereby petitioner was informed that if the petitioner fails to resume work within certain time, the agreement would stand terminated. It has been contended by Mr. Bhattacharya representing the petitioner that the stand of the that the contents of such termination order can ought not to be supported, since previously with a letter dated 13th August 2012, the municipality asked the petitioner not to carry out the work. Therefore, situation goes to show, as it was subsisting in the year 2012, that contradictory letters were issued by the municipality in the month of August and in the month of August, September, in the month of August, September, and October 2012. Since the municipality and HDA were at loggerhead during such time. During such time. Next paragraph. It is submitted on behalf of the petitioner that though prayer has been couched against tender notice dated 5th February 2016 in this petition, but the prayer is couched within bracket small c, within bracket small c, should be construed in a way based on which legality and validity of the termination letter dated 5th October 2012 can be examined. Semicolon, since in prayer C, writ of mandamus has been prayed for to allow the petitioner to continue and complete the work which the petitioner is required to perform in terms of the lease agreement. The learned advocate representing the municipality has placed reliance on the relevant part of the lease agreement dated 5th October 2010. 5th October 2010, 12 known. Whereby it has specifically been stipulated wherein it has specifically been stipulated that the petitioner being licensee needs to complete entire beautification work and other allied work within 2 years from the date of execution of the lease agreement. It has been submitted that the lease rent of 2,25,000, 2,25,000. It has been submitted that the lease rent of 2,25,000, yearly lease rent of 2,25,000 was paid by the petitioner for first 2 years from the date of execution of lease agreement, but subsequently till date, no lease rent has been paid. Maintainability of this writ petition has also been questioned jointly by the learned advocates representing the municipality and HDA on the ground that in the writ petition, challenge has been thrown to the tender notice dated 5th February 2016 in order to prevent the concerned respondent authority from issuing from issuing tender in favor of tender / work order in favor of other parties. But the termination of lease which has been made by the municipality with a letter dated 5th October 2012 has not been assailed in this writ petition. Stop. Next paragraph. Additionally, a point has been taken on behalf of Haldia Development Authority, on behalf of HDA, that till the year 2004, municipality was authorized to execute lease in favor of the petitioner in view of there was a lease agreement in between the HDA and municipality.
From
in view of the lease agreement which was executed by and between Haldia HDA, by and between HDA and the municipality.
My lord, R3.
Stop.
Page 24 of my affidavit in operation.
Stop. However, this lease agreement was however, the lease agreement dated 5th October 2010 was executed by the concerned authority or municipality, which according to HDA is not permissible, since in the year 2010 it was not within the domain of the municipality to take such stand in connection with the water body and the land in question. To take such step such step. Next point. Having considered the submissions made on behalf of the parties and on perusal of the relevant materials available on record, this court needs to consider the conduct of the petitioner for granting relief in connection with the present writ petition as prayed for. The petitioner entered into an agreement with the municipality on 5th October 2010 with the condition that he would complete the specified work at the land and water body in question within a period of 2 years. And there was also an agreement to the extent that the said lease would have lived for a period of 30 years on payment of yearly lease rent of 2,25,000. 2,25,000. The petitioner in his turn paid yearly lease rent for a period of 2 years and thereafter stopped paying such lease rent, and also did not also could not complete the work which was required to be finished within a period of 2 years. In support of failure of the petitioner to complete the work within the specified time of 2 years, it has been submitted by the learned advocate representing the petitioner that due to the situation which evolved since HDA and the municipality were at loggerhead, and the prevention at the instance of the HDA on making complaint before the police authority, the work could not be completed within the stipulated time. However, on perusal of the relevant documents and the letters made by the letters preferred by the petitioner before the concerned respondent authorities, it transpires that all these documents / letters pertains to 2012 onwards. Stop. The complaint which was lodged by the HDA before the concerned police authority was also dated 4th July 2012. Question crops up: what steps petitioner did take after execution of lease deed on 5th October 2012 till the beginning of after execution of lease deed বললাম ডেটটা বলো না 5th October 2010 তারপর কি বলছিলাম till the beginning of the year 2012. This court has made an attempt to find out an answer from the pleadings made on behalf of the petitioner, but no explanation has been given in order to point out the progress of work made during the period from October 2010 till the beginning of 2012. The contradictory letters issued by the issued on behalf of the municipality may not be supported while adjudicating this writ petition, but at the same time, this court is required to find out the contemporaneous steps taken by the petitioner on receipt of letter of termination dated 5th October 2012. There was no complaint, comma, complaint no steps were taken within time. No legal steps were taken within time. No legal steps were taken within time on receipt of this letter of termination. And after approximately 3 years, present writ petition was instituted, questioning the notice, questioning the tender notice dated 5th February 2016. It is settled principle of law that in appropriate case, the defect in the prayer can be cured, provided there is appropriate pleading in the pleadings in the writ petition. This court does not find any ground or pleadings being made in this writ petition which are directed against the legality and validity of the termination letter dated 5th October 2012. Stop. This court is also aware of the facts that after 20, when last paid lease premium, lease rent, 2012. This court is also aware of the fact that after payment of lease rent, after payment of yearly lease rent in 2012, till date, nothing has been paid by the petitioner. Semicolon. If in the backdrop of aforesaid semicolon, a full stop diba. In the backdrop of aforesaid facts, today, if the writ petition is allowed, permitting the petitioner to retain the land and water body based on the lease agreement dated 5th October 2010, then it would lead to a situation where without making any timely payment of yearly lease rent for a period of more than 10 years, petitioner would be permitted to enjoy the land and water body measuring 9.68 acres, which cannot be countenanced. Next paragraph. In the in above prospectus, this court does not find merit in this writ petition and the same stands dismissed. The interim order passed by the coordinate bench.
Pursuant to the letter
I have not finished.
2nd March 2016.
2nd March 2016 stands vacated. Next paragraph. However, considering the predicaments which the petitioner faced in the year 2012, which is after 2 years from the date of execution of lease agreement, dated 5th October 2010, in view of differences which was persisting in between HDA and the Haldia municipality, taking note of the fact that the petitioner deposited lease rent of 2 years, it would be 2 years, it would be taken out 2 years, comma, this order shall not preclude the petitioner to approach the civil court for payment of necessary compensation. Next paragraph. Yes.
I am submitting one thing, my lord. Pursuant to the letter of the Development Authority, my lord, the lease time is extended for the period 2090. Lordship can diagnose alignment to execute the deed.
That is not required. It is not the issue here. In between the interstate right of the right of HDA and the municipality, that is not the issue to be decided by this court. Since the submission has been made, the submission of the learned advocate representing HDA is merely recorded, nothing else. I have not decided that who was the authority, appropriate authority having power or right to execute lease in favor of the petition. Court has proceeded on the premise that a lease was existing in favor of the petition.
My lord, can too, my lord.
Yes. Next paragraph. Next paragraph. However, there shall be no orders to cost. Application, comma, if any pending, also stand. Your application.
My lord, my application for appropriate orders to maintain the water body.
Also stand disposed of. Also stand disposed of. Urgent Xerox certificate.
Grateful, my lord.
Grateful.
Item number 9.
Where is Mr. Mojumdar?
He is on his legs, madam.
Come back on next Monday. But it will take some time.
Yes, it
My lord, indulgence, my lord. My lord, I'm appearing for respondent number 11.
Come back on next Monday, next matter.
But only one thing, my lord, may I just point out, my lord?
Not today.
Item number 10.
My lord, I am for the petitioner. The grievance of the writ petition has been resolved, and kindly dispose the writ petition and recording the order.
So issue has already been resolved. Issue. The learned advocate representing the petitioner submits that the grievance of the petitioners stands redressed. Next paragraph. In view of aforesaid submission, no order need be passed on this writ petition and accordingly same is disposed of. However, there shall be no orders to post urgent xerox certificate copy.
Item number 11. Madam, for the Howrah Municipal Corporation, I'm led by Mr. Shandipan Banerjee in this question.
Who is for the petitioner?
I'm for the petitioner, Lordship.
Yes. Place your case.
Lordship, in earlier occasion, there is a direction to file an affidavit in opposition, Lordship.
Yes.
They have not filed the affidavit in opposition and that not been served upon. For last occasion, I have already asked the officers of the Howrah Municipal Corporation to make an inquiry and send us a report with regard to the present structure. Now, my lord, I will get it within 2 or 3 days. My lord, kindly give me some time to file an affidavit in opposition. Or, my lord, may I pay one indulgence?
It's a case of illegal construction.
Lordship. They have already sent one, my lord, letter by way of an email. That is at page 18. If Lordships, my lord, please to direct us to consider it, and if we found there is an unauthorized construction, we can start a 177 proceeding.
Well, is there any private respondent?
Yes, they have initially appeared, but last occasion they did not appear.
Have you served notice upon the private respondent? Where is the notice?
The affidavit of service may be kept to
Already filed.
Filed.
But that is before the different court.
Yes, your lordship.
So you have to serve upon the private respondent, indicating that the matter is to be taken up by this court.
Lordship. Then a notice may be
Why you are making a
subsequent-
submission which would lead to this court to read your affidavit in opposition?
Lordship, in the year of 2020, this matter was filed. Lordship, since then it is pending. And subsequently, matter was heard in earlier occasion before your
File your affidavit in opposition within this time.
Lordship,
In the
I will
meantime, I'll direct the petitioner to effect service of notice upon the private respondent.
Upon the advocate who was appeared in earlier occasion, Lordship, or to the petitioner, to the
There are-
respondent? They have appeared, your Lordship.
There are 4 private respondents.
Yes, your Lordship.
At the time of call, respondent numbers 3 to 6 are not represented. Stop. The next paragraph, the learned advocate representing Howrah Municipal Corporation has prayed for accommodation to file, has prayed for extension of time to file affidavit in opposition. Next paragraph. Let such affidavit in opposition be filed by 2 weeks from date, and affidavit in reply thereto if any be filed within 1 week thereafter.
Definitely.
Next paragraph. The learned advocate representing the petitioner is directed to serve notice upon the respondent numbers 3 to 6. Respondent number 3 to 6. Respondent number 3 to 6. Or the learned advocates of those respondents enclosing copy of this order by 10 days from date and file affidavit of service on the adjourned date. Next paragraph. On receipt of notice, respondent numbers 3 to 6 shall also be at liberty to file affidavit in opposition within 2 weeks thereafter. Next paragraph. List the matter under the same heading in the monthly combined list of June 2020. I'm correct. Next.
Item number 12.
At the time of call, no one appears. At the time of call, no one appears for the petitioner and no accommodation is paid for. Same situation prevailed on 28 March 2024. Stop. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Interim order, if any, stands vacated. Urgent Xerox certificate copy.
Item number 13.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Same situation prevailed on 28 March 2023. So it appears petitioner has lost interest. Writ petition stands dismissed. Interim orders, writ petition stands dismissed. Interim order finish stands vacated. Urgent Xerox certificate copy. You are appearing for the corporation, Mr. Banerjee? Are you appearing for the corporation?
Yes.
Just a minute.
I'm sorry, I have got 14, my lord. I'm sorry.
ঠিক আছে।
Item number 14.
And for the corporation. Here is a case, my lord.
Yes.
Their construction is unauthorized. Corporation took steps for laid on notice of.
Is not required because the petitioner is not appearing. I have to dismiss the matter for default.
And the corporation
Yes, sure,
decided
sure.
to take steps under 400 surface.
পিটিশনার যেহেতু নেই ওই জন্য ডিসমিস ফর ডিফল্ট করছেন।
At the time of call, no one appears for the petitioners and no accommodation is paid for. Stop. However, Kolkata Municipal Corporation is represented by learned advocate. Next paragraph, same situation prevailed on 28 March 2024. Stop. It appears petitioners have lost interest. Writ petition stands dismissed. Interim order finish stands vacated. Urgent Xerox certificate copy. Next.
Item number 15.
Ashun. Yes, sir. At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Same situation prevailed on 28 March 2024. It appears petitioner has lost interest. Writ petition stands dismissed. Interim order if any stands vacated. Application, if pending also stands dismissed. Urgent xerox certificate copy. Next. বলে দিয়েছি।
Item number 16.
Sure. At the time of call, no one appears for the petitioners and no accommodation is prayed for. However, Kolkata Municipal Corporation is represented by learned advocates. Next paragraph. Same situation prevailed on 28 March 2024. Stop. It appears petitioners have lost interest. Stop. Writ petition stands dismissed. Interim order if stands vacated. Urgent xerox certificate copy. Next. Combined লিস্টে যাবে তাই তো?
Item number 110 from monthly list of appellate side.
I appear for the respondents.
One.
Malat 110.
Madam, Mr. Raghunath Chakraborty is appearing for the petitioner. He is addressing court number 24. Kindly accommodate for this day.
Who is respondent number 24 and 25?
24 and 25. You know them. It's 21.
Private parties. What is the matter?
I do not
But
know.
last occasion, one Mr. Ahmed appeared.
Yes,
not
but he
Mr.
is junior,
Chakraborty.
but both of them are engaged in court number 24. Mr. Ahmed is junior to Mr.
So
Chakraborty.
that filling up
Yes,
of
yes.
pond,
You once, my lord, the
and there are occupants in the
my lord, initially building was
in the
there.
premises. Then an application was taken out for being added as a party respondent. That application was allowed. Amendment was made. Now it is to be heard.
Kindly email and accommodate for this day.
You are for the corporation. You are
No, I am for not. I am for the corporation. It's not that, my lord.
For on behalf of the Mr. Chakraborty.
I am paying for Mr.
What about the private parties? You are for whom?
I am appearing on behalf of the 24 and 25.
You have filed. You are the occupants. You are some of the occupants.
Some other parties are also there.
Issue. At the time of call, Kolkata Municipal Corporation, and you are for state. Kolkata Municipal Corporation, state respondent, and respondent numbers 24 and 25 are represented. Or go to the sentence পড়ো তো। And some of the private respondents are represented. Stop. However, No one is representing the petitioner. Next paragraph, in order to grant one more chance to the petitioner, hearing of this matter stands adjourned till Monday next. Monday next, comma, 29th, 29th April 2024. Or adjourned, hearing of this matter shall stand adjourned. Or hearing of this matter stands adjourned. Next paragraph, list the matter under the same heading in the monthly combined list of May 2024.
May.
Next.
Item number 115. Well, I'm filing my affidavit in reply against the opposition of the respondent number 4. All other exchange of affidavits already complete. Well, I've already served the learned advocate for the GBDA and affidavits exchange in between the Municipal Service Commission and others.
Because the video.
Yes, whether the affidavit in opposition has been filed by respondent number 4. This is your opposition. And what about the reply?
Well, reply filed.
Any other private respondents apart from respondent number 4?
Only one private.
5. Have you used any affidavit?
Yes, my lord, already.
Yes.
All exchange between the parties. Complete.
Your case.
Well, I will.
My lord, my respectful service of lordship.
I am ready.
This matter, I am led by Mr. Vikas Sanjan Bhattacharya. My lord, my senior just now left. I'm praying not today, only not today.
How Mr. Bhattacharya is a very busy counsel. In every matter, you won't get presence of Mr. Bhattacharya. Let me see. Let me have a cursory glance of the matter. Yes.
My lord, before I get into the merits of this case, my lord, I will place the order dated 16th August 2019 passed by this Honorable Court by Honorable Justice Somapti Chatterjee as his ladyship then was. And if lordship kindly...
What is the prayer in the writ petition?
Prayer for setting aside the appointment of the private respondent in a specific post of challenging literally his appointment to the post of assistant planner in Gangashagar Bokhali Development Authority. Before I
Who
get
is the
in,
appointing authority?
West Bengal, the selection is done by West Bengal Municipal Service Commission and the appointment thereafter made by Gangashagar Bokhali Development Authority.
Who is representing Gangashagar Bokhali? Whether the Gangashagar Bokhali has used affidavit?
Yes, ma'am. All affidavits exchanged between the parties.
Why you have challenged the notification dated 27th of May 2019?
Because it is my specific submission that on the date of...
What is the contents of this notification?
That on the date of the application, even till the last date of the application...
It is an employment notification.
Employment
Recruitment
notification. Employment notification. It is my case that the private...
Take me to this notification.
Page 31, annexure P3, page 31. Lordship may skip over to the second notification.
Page 31.
Page 31, annexure P3 of my writ application.
Yes.
Number 2, assistant planner.
2. That is the concerned post.
That is the concerned post.
Yes.
My lord, bachelor's degree in architecture, civil engineering with postgraduate degree in
Essential qualification. is this?
essential qualification.
Yes.
Bachelor's degree in architectural civil engineering with postgraduate degree in urban town city regional planning with recognized university or institute approved by AICTE with a minimum of 60% mark with at least 1 year's experience within bracket preparation of LUMR and LUDCP layouts and drafting, and my lord so and so. Now, my lord, it is my specific case that even on the date, and if lordship kindly skips over to page 33 for once.
Bachelor of degree, just a minute, degree in architecture, civil engineering with postgraduate.
Bachelor's degree in architecture, civil engineering, postgraduate degree in urban. My lord, these are not my questions. These are, I'm not agitating on those.
So what are the grounds of
1 year experience he was not having at the date on when he applied. This is a mandatory requirement, which he failed to have.
1 year experience, preparation of LUMR and LUDCP.
That's a post-qualification experience,
Design statements of
which the private respondent did not have, even on the date of closure of the application.
fields attending topics of public interest, understanding of child So all these rest of the issues, the candidate ought to have 1 year experience.
1 year, this experience along with at least 1 year experience in this.
There are many heads.
Many heads. Anyone.
Layouts and drafting design statements, evaluation on different proposals concerning architectural town planning fields, attending to public.
Oh, slash. Since this is also post of architect, that's why. They are all literally architects. And lordship may kindly skip over to page 33 for once. Here the last date is also given, page 33.
Fresh recruitment or a promotional?
No, fresh recruitment.
Fresh recruitment. Advertisement was published.
Advertisement published. Selection procedure conducted. But my case is on the date of application, he did not have the minimum eligibility requirement, educational qualification as was advertised in the notification. He did not have the 1 year requisite qualification.
On what basis you are making such submission?
All documents, everything enclosed in the writ
Now,
application.
in the affidavit in opposition of the respondent number 5, whether what is the stand? How the statements are made to
he has demonstrated
to show the compliance of this.
He has demonstrated how he is computing the period of 365 days. That is 1 year. I have also submitted documents which would clarify beyond doubt that he could not have had the experience of 1 year. Beyond doubt. Every piece of document is enclosed. And my lord, the affidavit in opposition of the Municipal Service Commission
has to be demonstrated by.
I have.
Yes.
My lord, and on top of that,
show me.
I will. And my lord, on in addition to that, the affidavit of the Municipal Service Commission assists me to some extent, wherein my learned friend appearing for the Municipal Service Commission in her affidavit in opposition admits that yes, on that date of application, that's the private respondent, did not have the qualification, but he had it on the date of interview. That one line submission is sufficient to allow my writ application.
Where is that admission? That is in the affidavit in opposition of the commission.
Of the commission. And may I show it just once, madam? If lordship takes up the affidavit in opposition of the respondent number 2 and 7.
Who is representing the commission?
My lord, Mrs.
You are for the selected candidate. Who is representing the general? Miss Coeli appears for the commission. In other matters,
no, she is appearing in
I
this
have
matter.
found her.
No, in this matter, she is appearing.
Where is she? It is an affidavit of whom?
Well, this is the affidavit by the Municipal Service Commission.
Name of the
respondent number 2 and 7.
Name of the deponent in the affidavit. Who has affirmed the affidavit? In order to find me, that will help me to find out the affidavit.
My lord, that I'm checking. This
Name is
some,
immaterial, only to find out.
This is some, my lord, Shotorupa Ghosh. She is the law officer, West Bengal Municipal Service Commission. Page 2. Respondent number 2 and 7.
Yes, Shotorupa Ghosh. It was affirmed. Just a minute. on 11 September 2019.
My lord,
Where is the statement made?
lordship may kindly skip over to page 4. Page 4, the first paragraph, I'm reading the last 6 lines. Lordship may kindly
The
skip.
respondent number 5 got appointed.
No, my lord, he was appointed, that is the private respondent. He was appointed as junior assistant planner on 7/2/2018 in the office of Gangasagar Bokhari Development Authority and worked there till 10/6/2019. And as such, on the date of interview, the respondent number 5 was possessing the required 1-year working experience as per advertisement dated 7/9/2018. So,
Possessing.
on the date of interview, and he is required to possess that mandatory qualification on the date of advertisement, at least on the closing date of the date of advertisement. How can he have that experience on the date of interview?
I was under the impression that he didn't have.
He didn't have. No, even I will
The last
demonstrate.
date of submission of submission of application he didn't have.
Even
But
while
on the date of interview he was
even
having.
I will demonstrate before your lordship that he could not have even on the date of interview. But let us go by the affidavit of my learned friend.
But if this is an additional qualification,
No, this is the
for a
mandatory
1-year experience.
Yes.
How does it matter if
This-
on the
that's
date
the-
of
that is- that
interview
is
the
a-
candidate is having
then if
the experience?
if
I
it
could understand if the candidate was not having this experience.
no,
at
no,
all.
my lord, subject to correction, if this would not have been an essential requirement or essential qualification, many others could have applied. Many others could have applied. The commission has to go by what it was published on the date of interview.
How you are placed in the panel?
Second person. I will require an hour's time. 1 hour I will complete. Any date. I'm ready with the entire brief. My lord. And one more thing, my lord, that
Which
was
judgment you would be relying upon?
my lord, I will
Shankar Mondal?
no, my lord, I will not place any judgment at the very outset. I will place Justice Somapti Chatterjee's order. Justice Chatterjee had restrained the respondent municipal authorities and all the respondents not to accord any sort of promotion and or benefits to the private respondent. It's apparent
in
this writ petition, and it's a clear case of contempt, because as of now I have intimation that he has been given a promotion, he has been given a pay fixation and all. Let the let Gangasagar Bokhali Development Authority say that they have not done anything in violation of her ladyship's order. I know that
is relating to contempt.
That
The
is
court
contempt.
considering the validity of the appointment made in favor of respondent number 5.
that GBDA is in contempt of the interim order passed
That
by this
court is
honorable.
not considering to do.
My lord, that's a secondary issue. I will be on the
That
main.
it is avenue is left open to you to initiate appropriate proceedings.
My lord, that I have not exercised. That I have not exercised. Otherwise, the documents on record and the admission of the Municipal Service Commission would prove beyond doubt that the private respondent could not have a requisite qualification of 1 year on the date of application, and even on the closure date of the application.
Writ petition is heard in presence of the learned advocates representing the parties, excepting Municipal Service Commission, West Bengal Municipal Service Commission. Stop. Next paragraph, affidavit in opposition has been filed on behalf of the respondent number 4, which is respondent number 4, and affidavit in reply filed on behalf of the petitioner are taken on record. Stop. Mr. Dev, learned advocate representing the petitioner, has made opening submission. Stop. Next paragraph, Mr. Shengupta, learned advocate representing respondent number 5, has prayed for accommodation. Next paragraph, list the matter under the same heading in the monthly combined list of May 2024.
Obliged.
Warning, indulgence one. Kindly fix the date.
হচ্ছে তো মান্থলি লিস্ট আমি
Monthly, dates.
এই ঘরে তো ওটাই নিয়ম মান্থলি লিস্ট তারপর নো ডেট ইজ পসিবল
This is my indulgence.